Joseph, I beg to mention item number 24 lost.
24.
Joseph, on the withdraw date with liberty to, if it's some technical difficulties here.
Withdraw.
Yes, with liberty to file a
24
claim.
for orders, no?
Yes,
24. Learned counsel, you are
I'm for the petitioner.
for the petitioner. Learned counsel for the petitioner. Please for withdrawal of the petition with liberty.
To file a petition.
With liberty to file a
Yes.
fresh. With liberty to file a fresh. Prayer is allowed. The petition is disposed with liberty to file a fresh.
Most of them.
May I, my lord? My lord, I would like to mention item number 27. Matter is fixed for supplementary hearing. I'm for respondent number 22 to 27. Matter may be listed after 2 weeks due to main counsel is out of station. And I have also taken consent from opposite party.
Item 27.
27.
You wanted to be listed for hearing
No, your
Adjournment.
adjournment.
on behalf of
On behalf of Mr. V. Arun.
this, that is petitioner, isn't it? Petitioner's counsel or respondent?
Respondent.
Respondent. It's mentioned as
Respondent number 22 to 27.
respondent 22 to
27.
It is.
And my lord, I am on
mentioned
behalf of the 18 to 21.
18 to 21. You also have no objection.
No,
Mention has been made on behalf of respondents 22 to 27 to list the matter after.
Yes, my lord.
After when do you want?
2 weeks.
After 2 weeks. The counsel for respondent 18 to 21 is also present. Petitioner absent.
I have already
Petition.
consent.
Okay.
K. Tama, leading counsel.
Oh, this is not the one. The previous one, that is 24. 24 is okay. The previous one which was mentioned, that is okay. So now this is 27, right? Okay, okay. They are praying for adjournment for 2 weeks.
I'm for it. Trying for
No, that's why I'm telling him. 22 to 24, no? Prayer is made for adjourning the matter for 2 weeks. Learned counsel for the petitioner has no objection. Prayer is allowed, list the matter after 2 weeks.
Much
Item
obliged.
27.
Hello, obliged.
Mayor,
Yeah.
I beg to mention item number 30.
13,
V.
30, yes.
The leading counsel, Mr. V. Damus out of state. Matter may be listed after 2 weeks.
Let it be 3 weeks, okay? Mention is made on behalf of Mr. V. Jamo, counsel for the petitioner that he is out of station. List the matter after 3 weeks for hearing.
May I, your lordship, I beg to mention item number 26. I am appearing on behalf of T. Bhagwan.
Okay.
I have taken consent from the other party also.
Appellant.
Appellant, your Honor.
Appellant. The appellant has prayed for adjourning the matter. When do you want?
26, item number.
26th of April.
Your Honor, item number 26.
No. When do you want?
After this holiday,
After holiday. For listing the matter, prayer is made for listing the matter after the BO break. List the matter after 3 weeks in the prayer of the appellant.
deeply obliged.
May I please, my lord, I beg to mention item number 20. My lord, we need a time to be taken a step.
20.
Appellant,
Item 20.
item 20, 20.
You need time to
Step.
take steps. Let it come up. Let it come up. Yeah. It's in order, orders only, yeah.
May I please read? Well, I beg to mention item number 28 and 29.
28 and
29.
29.
I'm making this mention on behalf of Mr. G. Taloyano, counsel for item number 28. He's
Okay.
currently out of station, so this matter may kindly be taken up after 2 weeks. ma'am.
Mention is made on behalf of Mr. G. Dalo, who is stated to be out of station.
I'm the counsel for item number 29. ma'am. Since the matters are related, they may
Related.
be fixed together.
And list the matter after 3 weeks. We'll put it after 3 weeks, okay? After 3 weeks for hearing. Item 28 and 29.
Deeply obliged.
May Your Honor, I can mention item number 15 and 16. Your Honor. In item number 15, I'm for the respondent and item number.
Just wait for some time. Let it reach item 15, 16. No? Okay.
My lord, this is given the revision petition of file under section 438, review section 442 and 528 of the NSS, praying for passing and setting aside of the order passed by ADC Balijan on 0307 07 0325. So, Your Honor, in this case, private respondent, who is from Taraso village, claimed that he has a plot of land there at Kamlakota village, Andhra Ruchi village. So, there was a resolution. Kindly see page number 25. A resolution in between people of Rusi village and Chera families of Taraso village held on 17 April 2016 regarding resettlement of Chera family at Kamlapota. The said meeting, GBs from so-and-so village were present and decided the case with the following resolutions. Number 1, the Chera family has to construct a house and settle at Kamlapota within 3 months. The Chera family shall organize community feast by sacrificing male mithun for the people of Rusi village in particular and Tapiso Panchayat in general to maintain age-old traditions and peaceful coexistence within 3 months. So this is a resolution passed by the people and GBs from different villages. So on the strength of this resolution, settlement agreement, can you see page number 31?
31.
Yes, 31. So may I read?
1 minute.
Yes. This deed of agreement is made at village Rusi and the Tapiso Panchayat of Sandupata Circles, Pampare, Arunachal Pradesh, on 16 April 16, 16 July 16, between people of village Ruchi hearing for a pass party on the part and Chera family having its permanent village at Tarasho under Tarasho Circle, Papumpare hearing called the second party. In continuation of the resolution adopted on 17 April 16 by the village authority and panchayat leaders present, the second party is carrying out resettlement process with the first party, in particular, and Tapiso Panchayat in general at Kamlapata on 16 July 2016. So on the basis of this settlement agreement, because
So as a continuation of the resolution, this
Yes.
agreement was entered in.
entered in, yes. So thereafter, in this agreement, and even in this settlement agreement and resolution, I, the petitioner, was not the signatories.
You were not the signatory.
Yes, I have not put my signatures because I have not given consent.
Then what happened?
And in the settlement also, there were 22 signatories were there. But they are also from different villages. And in the resolution also, out of 20 signatories, only 10 person has put his signatures, given consent. So what happened in this case? After this settlement agreement and resolutions on 2016,
Mm.
because I have not given consent, even because they are claiming the land as their ancestral land, because they are from different areas, Tarasu village. Now they're claiming their ancestral land in my land, in my area, Gushi village. So
So the FIR was filed
yes,
against
FIR
you.
was lodged against me on 12/12/2023 for trespass and breach of trust and for illegal construction at Chaira community land at Kamlapota. So after receiving of this FIR, police had carried out investigation, but finally the case was forwarded into non-FIR before ADC Balijar. And kindly see page number 40. Sakarpara. 27 December 2023, Sibraman Captain appeared OCPS and gave assurance that he will not repeat for a further encroachment to Chaira land, but he is not adhered to his promise made by OCPS. Still, he is indirectly putting other persons to create disturbance over Chaira community land. Therefore, praying your honorable court to executive magistrate bond under 1071 Code of CRPC against so and so of Rusi village, because there is likelihood of COVID breach of peace enclosed documents submitted by Charatagi. This is the non-FIR
Okay, then after
report
that,
submitted by the OC. Then on the extent of this non-FIR, ADC, LEC page number 41.
BBC passed this.
Yes, ADC has passed status code. Then subsequently, the next page, page number 42, the private respondent has filed a complaint before the ADC Balijan.
So you were directed to maintain status quo.
Yes, after
Yes.
passing
Then-
order. Then ADC, after receiving of this complaint, he had conducted a hearing by summoning some GVs from different villages. And let's see page number 49 and excerpt 5. These 7 GVs from different villages were called and hearing was conducted on 7/3/2025.
7/3/2025.
Yes,
And extra 6.
Annexure 6. Yes.
Yes.
So I being aggrieved by this.
So what did the
evening order.
ADC say?
Yes, this is kindly see operative person, page number 51, last page. In view of the above, I am of the considered opinion that the decision passed by the Gaon Boras in aforementioned dispute between the Chaira family and villagers of Rusi village in fair and just. Accordingly, by the power conferred to me under 45(2)(b) of the Assam Frontier Administration of Justice Regulation 1945, Section 4I of Arunachal Pradesh Civil Codes Amendment Act 2022, I hereby upheld and enforce the decisions of Gaobura passed on the settlement agreement dated 16/7/16. Therefore, in exercise of my power as an executive magistrate, Sri Namam Kaptin of Rusi village and his wife, Sri Nawam Makir and 1 Nawam Mania are directed to refrain from encroaching the land of affected parties and harming the peace and tranquility of Rusi village, failing which the office shall have no choice but to prosecute them under 223 of BNSS. The party aggrieved by this order are free to approach the appropriate court. So, my lord, in this case, how the ADC has executed the settlement agreement. It is 16,716. He doesn't have any authority to enforce, to execute the settlement agreement, which was entered not by me, by some other person. And had this been the decision of the village authority, then it could have been. But here in this particular case, the settlement agreement cannot be enforced by the ADC by invoking the provisions of Arunachal Pradesh Civil Code Act. By passing this order, ADC has directly,
So you're
indirectly,
saying that in a criminal case,
yes,
civil dispute has been settled.
yes, this is a civil dispute case. They could have filed a title suit before the appropriate forum, appropriate civil court.
Yes. Who accepts notice? This is an application under section 438, read with section 442 and 528 of the BNSS. Praying for quashing and setting aside of impugned order dated 7/3/2025, passed by the Additional Deputy Commissioner, Papumpari District, Palijan, come Executive Magistrate, in favor of the respondent number 2. Stop. Bernard PPL Hage accepts notice on behalf of the state respondents. The petitioner shall take steps for service on respondent number 2 by registered post with AD within 3 days. The notice is made returnable within 4 weeks. Any interim prayer?
Yes, my lord, interim, at least operation of 7/3/25 may be stayed till disposal of this instance.
In the
Yes.
interim, the operation of the impugned order dated 7/3/2025, passed by the ADC cum Executive Magistrate Balijan, shall remain stayed till the next returnable date.
Much obliged.
Please after us.
4 weeks.
Like.
May I please, your lordship? If this civil revision commission, lordship.
Hmm.
Lordship, we are agreed by the judgment and order dated 25 February 2025, passed by the appellate court, who is the civil judge junior division. Now, as per AP Civil Code, they have been empowered to be the
Yeah.
appellate court
Yes, I'm
of
not
the
familiar with this, your AP Civil Courts Act, no? So appeal will lie to JMFC.
lordship. There is a act
Okay.
recently. Act has been passed. It's a AP Civil Code Act. So as part of lordship, there are hierarchies of civil courts.
Hmm.
Now, as part of this act, civil judge junior division has been designated as the first appellate court.
Do you have a copy? The Civil Courts Act. Do you have a copy
Lordship,
with
I
you?
have the copy. There were after enactment of this AP Civil Code, after that, there were subsequent two amendments that has taken place.
Just show me the relevant portion.
Lordship, Lordship, before this, there was one regulation, another act, 1945, AFR, which totally coded
Assam Frontier.
Assam Frontier
Regulations.
Administration of Justice Regulation. That has been, in fact, some amendments has been taken place after enactment of this AP Civil Code. Lordship, may kindly see section 15, Lordship. Page 3 of the Act.
Section 15,
Section 15.
appeals.
Appeals, Lordship. Now, Lordship will directly come to subsection 3 of section 15, Lordship. Initially, Lordship, the decision passed by the customary court, that was to be appealed before the Deputy Commissioner. But after this enactment of this particular act, now it has to be before the Civil Judge Senior Division or Civil Judge Senior Division, or before the Additional District and Session Judge, District Judge, or the District Judge. Lordship, may kindly take up, this has been subsequently amended in the year 2022. Lordship, we having the copy, Lordship.
Amendment Act of 2022.
Lordship, may kindly come to section 3, Lordship. Amendment of subsection 3 of section 15, Lordship.
Three plus one.
3 clause 3, Lordship. Next page, Lordship. After the fourth provision to subsection 3 of section 15, the following subsection shall be inserted. An appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary affairs court by whatever name called, which shall be settled as per the local tradition custom under the provision of section 50 of the Assam Frontier Administration of Regulation 1945, provided that an appeal against the order of the inter-village territorial court of affairs customary court shall lie before the court of civil judge junior division, the courts of civil judge senior division, the courts of additional district judge, or the court of district judge, as the case may be, as per their territorial and pecuniary jurisdiction. Provided further, the courts of civil judge junior division, the court of civil judge senior division, the courts of additional district judge, or the court of district judge, as the case may be, shall not set aside an appeal so filed merely on a technical ground or procedural lapses, but in the interest of justice shall dispose the same as may be deemed appropriate and proceed the case denoted. Now, as per this act, the civil judge junior division has been empowered to be the appellate court, first appellate court. Now, herein in my case,
You can
Lordship,
either go to the civil judge, junior or senior, or even before the territorial customary court, depending on their choice, isn't it? Because here it says, if agreed to by the parties, they may an appeal against the order of, an appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary court.
this is Lordship, this is different as aspect, Lordship. There is a that is almost similar to village authority, Lordship. There is again a hierarchy that is coming, Lordship. Bango level kava, district level kava, Lordship. That is different, like. If the parties agree, they can opt that options also. They can opt this. There are two options that can be opted by
Against
the
that higher-
litigants, Lord.
Higher one, higher court, then the appeal will lie to the civil judge.
Lordship.
Mm.
If they are agreed directly, they can approach either ways, Lordship. there are two options that is open for the litigants.
To village territorial court or which? Depending on the territorial and pecuniary jurisdiction.
Your Lordship.
Okay.
Now, hearing in my case, Lordship, before enactment of this particular act, there was a dispute between the petitioner and the respondents, Lordship, in regards to Dante area, Lordship. Now, accordingly, both the parties, one of the petitioner has approached the deputy commissioner. And upon receiving of that complaint, Lordship, Lordship may kindly come to page 27 of my petition, Lordship. By this order, Lordship, a village council was set up, Lordship, constituted by the deputy commissioner, Lordship, before enactment of this particular AP civil court, Lordship. Now this is going as per AFR, Lordship.
This is
Now-
before coming of the civil court.
Civil court, Lordship. Now, accordingly, 6 members of Gamburas was constituted, and it was directed to be supervised by 2 public interpreters, political interpreters, Lordship. PIs, in short, we call it as PI, Lordship. With certain terms and conditions, and this is the order passed by the deputy commissioner in order to settle the dispute between both the parties, Lordship. I have copy as at page 48, Lordship, or 28, Lordship. Lordship will find the deputy commissioner has fixed the date and the place for conducting the meeting, conducting the Kavang, Lordship.
Then what happened on?
And thereafter, Lordship, under the supervision of these 2 public interpreters, Lordship, one Kava order was passed, Lordship. Lordship will find it page 31.
Page?
Page 31, Lordship, and except 2.
Hmm.
Now, this order came into being, Lordship. The Kava, the 6, in fact, 6 was constituted by, but 5 participated, Lordship. 5 GVs participated, and they delivered their judgment, Lordship, which is at page 31, Lordship. Now, here, Lordship, the Kava members, Lordship, by this order, pass the order in my favor, Lordship. Lordship will see at page 39 the operating procedure, Lordship, decision,
39.
which is duly signed by all the GVs, Lordship.
Yes. In favor of the mayor and two plans stating that.
In fact, the dispute was between 3 clans, Lordship. Yun clan, mayors, and the Pul clan, Lordship.
Then you are.
I am belonging to Pul clan, Lordship. PUL, Lordship, Pul clan.
Yes, so it was given in your favor.
The
Can you
under,
accept that?
Lordship, I am reading out the decision, Lordship. The undersigned village authorities appointed for hearing the proceedings after going through all the details, points placed before them, took a unanimous decision in favor of the mayor and Pul clan, stating that Chat Kattal is and has been the boundary in between the Mismis and the mayors. Therefore, the claim made by the Yun clan is declared null and void as per the limitation period of appeal provided as in the Assam Frontier Act 1945. The aggrieved party may appeal within 30 days from the issue date of this order. Now, after this being aggrieved, the respondents, they have filed one appeal before the deputy commissioner also. Now, this appeal also before enactment of this AP civil court also. Now, this appeal was pending, Lordship. Now, in the meantime, the appeal civil court came into being, Lordship. Now, in that AP civil court, there is a clause saying that if the deputy commissioner is not taking up the matters within 1 year, they have to commit it to the respective appellate court prescribed under the new act, AP Civil Court Act. Accordingly, Since the deputy commissioner was not taking up this appeal, accordingly, the matter was transmitted to, committed to the
To the civil judge,
district judge, Lordship,
district judge.
district judge. Lordship will find the order of the district judge at annexure 4, page 55. Lordship. Now, when this matter was brought up before the district judge, Lordship, district judge found that the territorial jurisdiction of the dispute lies to the civil judge junior division, Lordship, Hawaii. So accordingly, by this order, the matter was again transmitted to civil judge junior division for adjudication of the appeal that has been filed by the respondents. Accordingly, Lordship, page annexure 5 series, page 56, Lordship. The case was put up before the civil judge junior division, who is acting as the appellate court, Lordship. Accordingly, several hearings took place, Lordship.
Okay.
And finally, and in the meantime, Lordship, we being the respondent in the appeal being filed by the appellant, who is the respondent in this case, we filed our reply to that, Lordship, which Lordship will find at page 61, which is marked as annexure 6.
Then what did the civil
And
judge?
preliminary, in fact, the appellate court, the preliminary issue was raised that whether the case is maintainable or not, Lordship. Accordingly, hearing was taken up. And on 25 February 2025, which is impugned in this order, in this civil revision, Lordship. Lordship will find at page 76, Lordship. Now, after hearing both the parties, Lordship, this impugned order was passed.
So why are you aggrieved by the?
Lordship, here, Lordship, the London Appellate Court below, Appellate Court has cited the reason of dismissing the Kaba order, Lordship, Kabang order, Lordship. They have, by this order, the Kaba order, which was put to challenge, was set aside and quashed. And border party was directed to approach the civil court for de novo trial, fresh trial. Lordship.
Let us see the operative portion.
Lordship, what operative portion is at page 81, Lordship. Last paragraph. Citing the reason that the Kawang order that has been impugned in the appeal petition does not have a reason order. It's not a reason order.
But provision is there either to set aside the Kabang order or to have it de novo, isn't it? De novo
Lordship,
trials, isn't
provisions
there?
are there, but
Ah.
Lordship is aware that the law is settled, Lordship. For de novo trial has to be taken as the last resort, Lordship. Lordship has read the amended part of this section 15 also, Lordship. In that also, Lordship, it is clearly provided, Lordship. Last part of the paragraph, Lordship. I am reading it again, Lordship.
Dispose of the same.
Provided part of the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, the Courts of Additional District and Sessions Court of as the case may be, shall not set aside an appeal so filed merely on technical grounds, or procedural lapses, but in the interest of justice shall dispose of the same as may be deemed appropriate or proceed with the case de novo. Here the learned appellate court could have taken up the case de novo, lordship. He could have taken up the case de novo, lordship.
Now,
Now, but in his
if
order,
if the court did not find that there was any reasoning, it could have been taken up de novo.
lordship,
Mm.
there are provisions, lordship, under CPC, lordship, and lordship is also aware that the appellate court has the ample power to call for evidence, extra evidences from the learned court below.
It's okay, we'll issue notice. Learned counsel for the petitioner, she such and such. The petition, the present petition has been filed under section 115 of the CPC. Assailing the order dated 25/2/2025, passed in civil appeal number 19/02/2020 by the civil judge, Junior Division, Hawaii, HAWA, Hawaii, Anjao District, ANJAW, Anjao District, stop. By the impugned order, the learned civil judge, Junior Division, had quashed the Kabang order dated 23/1/2020 and directed a de novo trial. So, it is submitted by the learned counsel for the petitioner that the learned civil judge, Junior Division, Hawaii, had simply set aside and quashed the judgment of the village authority by citing the reason that the village authority had not given any reasoning in its judgment. So, it is also submitted that the learned civil judge, Junior Division, could have adjudicated the matter de novo as an appellate court. However, without doing the same, the order of the village authority dated, your Kabang order was dated 23/1/2022, was set aside and quashed. So, hence the present appeal, application under Article 227 of the Constitution. Issue notice returnable within 4 weeks. The petitioner shall take steps for service on the respondents 1 to 6 by registered post with AD within 3 days. Stop. In the meantime, the impugned order dated 25/2/2025, passed in civil appeal 19/02/2020, passed by the learned civil judge, Junior Division, Hawaii, shall remain suspended till the next returnable date. It's after 4 weeks.
All right.
What is this?
Where, before coming that, this is
Why
revision.
is it so voluminous?
The other party, he filed a civil appeal. This entire document is his document. So since I am challenging the order, that's why I have to bring on record. So my lord, I will just I'll take my lord to the very relevant documents only. No, we don't need to go entire document. My lord, this is a civil revision.
In this case, I am appearing for caveator. My lord.
Caveat can be discharged.
Yeah, maybe this. What is it? Caveat petition 34 of 2025. Item 3. Learned counsel. Just keep your
Ketama, Ketama.
appears for the caveat. Accordingly, the caveat is discharged. Then. Separate this screen, there is a kind of open the pages.
Since Lordship, there are other respondents also. So in the main case, notice may be issued. Even if
Let
there is
me-
any
let
urgency
me-
of hearing,
Before my
let the
legal
LCR
friend
be
makes
called as
submission, my lord.
because this
Let-
revision
let us
petition.
I am the
Hold on.
petitioner, my lord.
Let us hear the petitioner first.
My lord, this is a civil revision petition, my lord. Against the, my lord, interim order of the, my lord, dated 24/3/2025, passed by the, my lord, civil judge, senior division UPA, my lord,
Hmm.
my lord, in exercise of its appellate power
Hmm.
under order 41 of
Hmm.
the CPC.
Hmm.
Basically, my lord, the respondent number 1 here, my lord, he had filed civil misappeal
Hmm.
against the, my lord, temporary injunction order
Hmm.
passed by the Learned Trial Court, which
Hmm.
is a civil judge junior division UPA. Learned Trial Court was pleased after hearing the parties that there is a prima facie case, all the golden principles were taken into consideration. Prima facie case, irreparable loss of injury, balance of convenience, all those after that, a very reasoned and balanced order was passed.
Hmm.
Now, my lord, but the appellate court, my lord, exceeding the appellate power, my lord knows that why, because this appeal under order 41 of the CPC is not an appeal, regular appeal. It's the appeal in principle. It has a very limited scope, my lord. The appellate court has to see whether the order passed by the Learned Trial Court, my lord, whether it has not, whether it discussed the principles or not, whether there is a material to come to a very possible view or not. Only because the Learned Appellate Court thinks that it may have a different view, that itself is not a reason to interfere in the exercise of the discretion power. This is a settled proposition of law, my lord. Here in this case, what happened, my lord? Now, I will come to those order, my lord, one by one. Before that, my lord, some brief facts I just put on, I will just not make submission so that we can understand exactly under what circumstances this order has been passed. What happened, my lord? Petitioner here, petition number 1 and 2 and 3, my lord. They are the, my lord, president and general secretary of one branch student union. It is a, my lord, branch student, this is a federal unit of all NISI student union organization. This is a community-based student organization.
Well, Nishi Students Union.
Union. So, this petition number 2 and 3, under the bylaws of ANSU, my lord, they are entitled to participate in the election of the executive members of the ANSU,
Okay.
and they are entitled to send the delegates to cast vote in the election. Then some dispute arose between two parties regarding that who will be the representative of this particular federal unit to participate. Then, my lord, while order dated 25/10/2024 passed by the civil judge junior division zero, my lord. Now, this order is not in dispute. Till now, it is in valid operation that the learned civil judge junior division G passed the order saying that the petition number 2 and 3 will be entitled to represent the federal unit and they will be entitled to do all the activities. And the rival parties should not be allowed to represent this federal unit student branch. This order is not in dispute. They are also not disputing that part. This is clear. Now, what happened, my lord? After that, this election of the central executive member of the ANSU took place here. Then what happened? Since there is an order, valid order from passed by the judicial court, my lord, saying that the petition number 2 and 3 and their delegates should be allowed to participate. But this committee, members of the election committee members, my lord, who are the respondent here, they refuse to go by the comply with the order passed by the order dated 25/10/2024, passed by the civil judge junior division 0, my lord. First, non-compliance of judicial order, my lord, kindly note 25/10/2024.
2510.
2024, whereby, my lord, this petition number 2 and 3 are recognized as a legal valid representative of the branch student union. My lord, being aggrieved, since we were not allowed to participate, we filed title suit number 17 of 2024 before the civil judge UPR, junior division UPR, saying, my lord, since court has already recognized us as a representative, now as per the ANSU bylaws, we are entitled to participate in the election, and the other party, those who are making counterclaim, they should not be allowed to participate. Then this honorable court was pleased and order dated 14/11/2024 was passed. I will come to those documents later. 14/11/2024 in Miss case number 18 of 2024 was passed, saying that all the delegates recommended by the petitioner number 2 and 3 should be allowed to participate in the election, and the delegates recommended by the rival party, they should not be allowed to participate in the election. Very specific order was passed. Again, we went with the order. Again, they denied to comply with the order. Said that no, civil code has nothing, no business in our affairs. We will not comply. So under that circumstances, again we have to approach the court, saying that since they are refusing to comply with the order, kindly give us the assistance of the deputy commissioner and SP. And this honorable court, the honorable court, learned trial court, again passed an order on 21/11/2024, directing the deputy commissioner as well as the SP that you ensure the compliance of the order passed by the court and allow the petitioner number 2 and 3 as well as their delegates to participate in the election, to enable them to cast vote as per the. But the election committee members declined to abide by the court order, declined to abide by the order passed by the SPDC. Under that circumstances, DC and SP had to even withdraw the permission for further holding of the election. These all are in the document. I will refer those. Then thereafter, when this situation, then election result was declared. We were not allowed to participate. Then what happened? Petitioner number 1 hearing was one of the presidential candidates. Was one of the presidential candidates for the post of ANSU election. Then in the election, my lord, the result of the election happened in this way, my lord, that the petitioner number 1, he got the votes of 2,231. The respondent number 1, who has been declared as the president, he got the vote of 2,322. So there was a margin of 91 votes. Then, now the issue became like that, my lord, had those 54 delegates to which this learned trial court directed that don't let them to participate in the election, had we been allowed, our party, my lord, 51 votes, my lord, then the election result would have been in my favor. I would have won election by the 14 votes, my lord. And refusing to allow the petitioner members and their delegates and allowing the other party or the supporter of the this respondent number one, and in violation of the court order, thereby materially affected the entire election result. So that's why, my lord, again, title suit was filed before the learned trial court, my lord. And when the title suit was filed, my lord, then this injunction order, my lord, injunction order was passed saying that, my lord, injunction order was passed. Honorable court, after learned trial court, after taking consider all the aspects, in the my plate, my lord, there is a sufficient evidence, material documented, everything, that court's order, despite repeated multiple orders from the court, administration, all those things, they refuse to comply with the order. Therefore, there is a prima facie case to go for a trial. My lord can understand how any action which is taken in violation of the court order can be said to be illegal. Here in the case, I have support of 3-4 judicial order, and the court came to the conclusion this is a prima facie case, and there is a sufficient evidence, material on record, to show that there is a violation of the court order, and in violation of that court order, the election process initiated. And therefore, the learned trial court, considering the balance of convenience and irreparable injury, because otherwise matter will become infructuous matter. So that to protect all those interests, the learned trial court passed the order restraining respondent number one from representing as the president of the ANSU. Madam.
So that is 28-1-25.
Madam. Now, 28-1. So that order I will refer, madam. It's a very balanced order. Opportunity was given. No ad interim injunction was passed. Considering all the materials in the interest of all the parties concerned, so that the subject matter has to be kept alive, madam. And it is a very strong case, strong prima facie case to go for a trial. The issue raised is that whether in violation of the court order, if somebody hold the election and because of which the election result is materially affected, then whether this is not a prima facie case, my lord, to go for a trial. And the trial court says this is a very strong prima facie case. This injunction order was made absolute. And appeal was passed. Then they preferred appeal before the appellate court, which is civil judge, senior division. Initially, the respondent asked for a stay of that order that was denied by the appellate court. Appellate court in its own order says that the learned trial court has discussed all the 3 golden principles for granting of the temporary injunction. So there is no question of any stay. Being agreed by that, the appellant approached this honorable court invoking 227, Article 227, challenging the order of the appellant. This honorable court, after hearing the parties, was pleased to dismiss the revision petition filed by the respondent. Holding, but categorically observation is there, I will just show, my lord. When you're saying that the learned trial court has thoroughly discussed all these principles, therefore this is not a case where this revision power should be invoked. Now, very interesting. Then, main appeal argument took place. Judgment was reserved. Then, my lord, the interim judgment happened to be passed. The reasoning given in the interim order, my lord, I will before coming. It's very interesting. The learned appellate court has not properly discussed about all these principles. Very erroneous approach has been taken in the sense, my lord. Now, the learned trial appellate court is saying that how the learned trial court can come to the conclusion about the violation of the court's order and without holding the trial. So this predetermination is wrong, and therefore the entire temporary injunction order, that is only the ground. Now, my lord, let's understand that. why the approach of the learned appellate court is wrong. Now the appellate court has misdirected itself, my lord. My lord, how to find out the prima facie? What is the approach to find out whether there is a prima facie case? No, it's very simple. How the prima facie? It is not something learned trial court has not given the conclusive determination that he has committed the contempt. But to come to the findings that there is a prima facie case, definitely learned trial court has to go through the record and has to be satisfied whether there is a violation of the court order or not, madam. This is the prima facie opinion has to become, madam, saying that so that trial can go for in future. Here in the case, learned trial court, of course, had to discuss about the violation of the court order because my entire title suit is based on that non-compliance of the court order has materially affected, and that's why, my lord, that discussion has to be done by the learned trial court, my lord. Otherwise, how the learned trial court will come to the conclusion where the prima facie case has been made or not? Now, the learned appellate court is saying that why the learned trial court below has discussed about the matter that whether the court order has been violated or not, so that it has predetermined. So this is basically the case. Now I'll come to the documents one by one. Then I will make submission about the grounds. Now, my lord will find
You first show me the court orders.
my lord, first order, my lord.
Yes. Page,
Page 190. My lord, may I check to the, my lord, strictly starts from page number 192, my lord. 192. One by one, I will come, my lords. I will show some orders first, my lord.
192. Yes.
Here, my lord, you will find page number 194, my lord. From the bottom, my lord, second paragraph, my lord. Second, as such, upon being satisfied with the submission made by the petitioner plaintiff, I am inclined to allow
Wait.
page 194, my lord.
94. Okay.
At the bottom, my lord, second paragraph.
As such,
As such, upon being satisfied with the submission made by the petitioner plaintiff, I am inclined to allow the prayer of the petitioner plaintiffs and direct that the operation of the notification dated 9/11/2024 and notification dated 12 so and so are suspended till further order. Further, the defendants and in particular defendant number 1 to 8 are also directed to enroll the names of the plaintiff. And my lord, next one, page number 195, my lord. Delegates recommended by the plaintiff number 1 and 2 in the list of delegates for ANSU election 2024, and they be allowed to participate, contest, and vote in election. My lord, with this order, my lord, this petitioners 2 and 3 and their delegates yes, ma'am. Further, the plaintiff so and so, thereafter, my lord, and defendant number 9 to 12, my lord, this is very important. Defendant number 9 to 12 and defendant number 13 to 63 be prohibited to participate in the ANSU election 2024 as members of the so and so and so. These are the, my lord, delegates of the rival party. They were categorically prevented by this order. Now, my lord, when this order were not complied, my lord, then my lord will come to page 227. again, I had to approach the trial court since they refused to comply with the order, my lord. Then this order was passed, my lord. A type copy, my lord, will find, my lord, operative portion, kindly turn to page number 228, my lord. 228. From the bottom, my lord,
This is again under, before Civil Judge Junior. UP.
yes, my lord,
This one
because earlier order was not compliant.
also complaint.
That's why again I had to approach my.
Mhm.
My lord, may I check you from the bottom, my lord, second paragraph, 1, 2, 3, 4, fourth line from the bottom, my lord. I am inclined to direct that the Deputy Commissioner, District Capital, SP Capital, to provide assistance to the petitioner in the present case in ensuring the compliance of the order dated so and so and so. But very unfortunate, my lord, even DC and SP my lord, failed, my lord. Then my lord will find page number 231. Page number 231, type copy, you know. Type copy, my lord will find it page number, starts from page number 233. Relevant portion, my lord, I will read page 234. 234. This was, my lord, Deputy Commissioner
This is DC's order.
DC order, saying that the learned civil judge unit division has passed the order. You comply with the order. But again refused, my lord.
Where is that? Therefore, such and such. Hereby directed to allow such to participate in the election process.
Without fail, comply the order dated so and so, my lord.
So this Vicky Tanya and.
Yes, Vicky
Gokia
Tanya is the, my
and
lord, petition number
here
2,
petition.
2 and 3. Then, my lord, next is the page 235, my lord. This is the Superintendent of Police issued by the Superintendent of Police, saying, my lord, that they are not complying with the order. That's why we will withdraw the permission for the permission to further hold the election process, my lord. May I take to, my lord, this type copy, my lord? Page 236A, type copy, my lord.
Page 235A, I think.
236, my lord. 236A, type copy.
Oh, 236A. Yes.
Yes, my lord. My lord, from the bottom third line, my lord, in the light of above, I'll just read this one line, my lord. This is the letter issued by the Deputy Superintendent of Police. In the light of the above and compelled by the necessity to uphold the court's order, this office hereby withdraws the no objection certificate earlier issued under order number so and so, so, which permitted the conduct of the ANSU election 2024 election so and so. DC SP withdrew the permission. My lord, since they are not complying with the court order and not even their order, that's why SP withdrew the no objection order, saying that we will not allow you to pursue further with the election process. Thereafter, my lord will find DC order 237, my lord. Last paragraph. Last paragraph, my lord. This is the order issued by the Deputy Commissioner. Now, therefore, last paragraph, my lord, from the bottom, second. Now, therefore, in view of the above, the permission given to so and so to conduct 16 general election, all NISI students at Sidar is hereby withdrawn with immediate effect. The Superintendent of Police is directed to enforce this order so and so. Then this was also withdrawn, my lord. Deputy Commissioner also withdrawn. Then, my lord will see. Then when we try to, my lord, exercise our rights pursuant to the order of the civil court, my lord, then we were badly assaulted, our parties, my lord. And petition number 2 had to be even shifted to the medical, admitted, my lord. This other party, they were at all, my lord, intended to like allow us to participate in the election. All these things, we had to file FIR against them also, my lord. All these things happened. Then, my lord, this committee proceeded with the election, then election result declared, my lord. My lord, I will come to this election result. In the election result, my lord, we'll see page number 244, 249. My lord, let's read the page number 244, my lord. This is the chart of the votes, my lord, counting of the votes, my lord. My lord, one thing, my lord, may kindly take a note, my lord. Here, we are not challenging the entire election of the other executive body. We are only confined to the president.
To the president only.
Because, my lord, because margin of the vote is very low here. Because other candidate, although may be illegal, but their margins is very high. Even if we say that we may be allowed to cast the vote, that will not make a difference. Therefore, not challenging the others candidates in election. Only confined to this president. My lord, will see page 244. Ashok Doka, first at the top, my lord. The candidate of the president, Ashok Doka.
Yes.
He is the petitioner number 1 here, my lord. He was a plaintiff also. Petition number 1 here, my lord. And Lezen Gedi, third number, my lord. He is the respondent here. The appellant who got the favorable order from the appellate court, my lord. My lord, we'll see 2231, the Ashok Doka, my lord. Legend Gedi 23221. The margin is 91. Now, my lord, yes. Now, my lord, their delegates which were illegally allowed were, my lord, 54. So our delegates 51 were supposed to allowed to vote, my lord. And because of which, my lord, had the court orders been complied, then there would have been the by 14 margins vote, my lord. This Ashok Doka would have won, my lord. Then election result definitely would have been materially, my lord, affected, my lord. Now, thereafter, what happened, my lord? Page number, my lord, will see page 251, my lord. I'll just refer, my lord. This is the order, my lord, after election, since the matter is pending before the learned civil judge, my lord. Deputy Commissioner directed the SDPO police that you seize all the election related matters since the case is pending. This is the order passed by the Deputy Commissioner. The last paragraph, my lord. Superintendent of Police is hereby directed to the custody of all the election material in connection with the ensuing elections, so and so and so and so. But what happened, my lord? But this election committee, they refused to give the election related material and they burned all the election related materials even. But the SDO report, my lord, will find at page 252. 252.
Type copies
Yes, ma'am.
252A.
Yes, ma'am. Now, my lord, it was under such circumstances, this title suit number 21 of 2024 was filed by these petitioners before the learned trial court civil judge. Our basic case is that, my lord, the basic case is that since the entire election process was illegally held. Why illegally held, my lord? On the face of the multiple judicial order as well as the order passed by the administrative body, my lord. And there is even, my lord, ground report observer. I will just refer that page. Thank you.
So in your title suit,
My lord.
what is your prayer? Let's
My in title suit, my lord, my prayer is that, my lord, there's this result notification. May I take to my lord, this title suit, my lord? It's, from my title suit, my lord, will find. Page 62 to 105.
62.
Yes, my lord. One 101, my lord, is my prayer, my lord. Page number 101, my lord. Basically, my prayer, defendant number one, who is
Defendant
the,
number one by the election committee as illegal and void. And quashing the impugned election result as far as defendant 10 is concerned.
yes, my lord, who is the president, respondent number one here. That denial of both have fair election is illegal, my lord. Directing holding of fresh election for the post of president and permanent injunction. Thereafter, my lord, I file even miscase, my lord. My lord, my miscase starts from page 258, my lord. Then my prayer portion 270. This miscase, my lord, under
This case for
for temporary injunction. Yes, my lord. My prayer is especially, my lord, that for the suspension of the impugned notification result, my lord, during the pendency of the main title suit, my lord. Otherwise, my lord, if it is allowed not given, then my matter would become infructuous, my lord. So considering all those aspects, my lord, then, my lord, before that, my lord, may I take to page number 255, my lord? This is important, my lord. Page 255. My lord, this is important document, my lord. This document was prepared by the observer of the election. This is the official document of the answer election process, my lord. This is the observer. I will just read, my lord, one paragraph. I won't take much time. Page 255, para 3, my lord. Para first paragraph, it's saying about, my lord, that inside the election premises, money were distributed. All those things is not that relevant for me. Para 3 is important, my lord. Now the observer is also saying that the violation of the judicial authority, the Honorable Court, through its order dated so and so, had explicitly directed the Chief Election Commissioner to allow the delegates submitted by Bikitanya Higang and Suri Gokia Tame of the all Palin Chambang Yangte Gangte Taralangding student to participate in the election and exercise their voting rights. However, contrary to these directives, the delegates submitted by Sri Re Tahatim were allowed to vote. This blatant violation of the court's order undermines the legitimacy of the election process and constituted a serious breach of the judicial authority, my lord. This is, my lord, this is the ground report submitted by the observer, my lord, who appointed to look after the, my lord, this election process, my lord. My lord, fine. Let's come to, my lord, that
now show me the temporary injunction order.
yes, my lord. Now I'll come to that order, my lord, whereby this order was issued.
Page 363. 363.
My lord,
Resume at 2.
after break, my lord.
Yeah, that's right. It's the matter of the 4 weeks.
Much obliged.
My lord. On page number 1049, my lord. This is a temporary injunction order, my lord. 1049. Second copy.
Page
1049,
1.
1049.
Oh, this is only till 499.
Yes, madam. Next,
So next one.
next. For all these documents, it goes to my learned friend only.
10.
1049. This is the order, my lord. Order dated 28/1/2025. Whereby, my lord, learned trial court granted the temporary injunction order. The relevant portion I will read, my lord.
28, 1, 24.
Well, kindly turn to page number 1051. So discussion and reasoning of the order
1050.
1051.
1051. Hmm.
From the top, my lord, I'll read my lord.
Hmm.
Here the my lord, discussion is made why the injunction was granted. My lord. I'll just read my lord. From the perusal of the above, it is evident. My lord, the word used is evident. My lord. It is evident there was specific direction to the respondent number 1 to 9 by the order dated regarding the applicants therein to be allowed to contest the election and other party be barred from participating. The report of the official election observer and the orders of the deputy commissioner and the superintendent of police makes it evident. My lord, again, his word used is evident. My lord. Evident that the order dated was not complied in toto by the respondent number 1 to 9. The said violation was even after several interventions by the said authorities. So, from the above, it is crystal clear now that prima facie case is established in favor of the applicants. Now, my lord, prima facie case has been discussed because sufficient materials is there, my lord, to go for the adjudication, and it is evident, my lord, that there is a violation of the court order, my lord. This has been discussed. Now, my lord, and as submitted by the counsel of the applicant that the non-intervention of the court could result in irreparable loss by the applicant as the same cannot be compensated in monetary terms, it is seen that the applicant stands at losing his rights, which otherwise would have accrued to him had the election were conducted in fair and proper manner, and allowing the other party to enjoy the fruits of the illegal act by prejudicing the rights of the applicant would be a travesty of justice. This right cannot be compensated by bestowing upon the applicant by declaring the matter in its favor upon final adjudication of the suit at much later stage. Nor can the applicants be compensated in monetary terms later. Thus, it is also evident that the applicants have made out the irreparable loss in his favor. This court has carefully weighed and considered the harm that could befall on either party if the injunction is granted in favor of either party. The court is also not oblivious to the harm the respondent faces if the injunction is granted in favor of the applicant. At the same time, it is now also aware that the respondent have placed themselves in the way of harm by their own doing, violation of the court's order dated so and so. By an act of their own doing, they have also prejudiced the rights of the applicant. As rightly opined by the counsel for the applicant, the respondents ought to have complied the aforesaid order unless intervened by the appellate court. Non-intervention of the court in this matter would only legitimize the illegal act of the respondent by which the respondent number has come to find himself in the position to begin with. It appears that the applicants face more harm if the injunction is not granted in its favor than the respondent does. As such, in my considered opinion, the applicants have succeeded in making out balance of convenience in its favor. Resultantly, the prayer for injunction by the applicant is allowed. The operation of result notification with respect to so-and-so is suspended. Respondent is also barred from representing himself as president of so-and-so. He is also barred from using any sign, seal, emblem, or any other symbols of the office of the union. He says so-and-so, so-and-so. My lord, here all the aspects have been discussed, my lord. My lord, at this stage, what is the requirement? It's not something holding the trial. No, my lord. It is in the application under order 39. Now, whether those materials were available there before the court or not, my lord, supporting this conclusion, my lord. And the learned trial court, my lord. This is a discretionary power, my lord. This exercise is the discretionary power if there is a materials to come to the conclusion that the prima facie case is made it out of. The present case, my lord, when, my lord, I have brought on the record with the documents supporting that we were not allowed to cast vote as directed by the court, and there are sufficient documents to show evidently, apparently, my lord, that, and because of the election has been materially affected, that's why, my lord, the learned trial court has found that, and to find out the prima facie case, my lord, this discussion has to be made, my lord. Because my case is based on that one, my lord, that since it has not been complied, that's why election result has been materially affected. Now, my lord, on that basis, it is a very reason and balance order has been passed, my lord, considering all the aspects. Now, my lord, let's see the impugned order, my lord. How the learned appellate court, my lord, come to the conclusion this order is bad, my lord.
Page
But, my lord, page starts from page 24, my lord.
24 of this
First
second one,
page.
or the first one.
First. So, voluminous. I'll just take relevant portion, my lord. Starts from page number 24. This is the impugned judgment order.
20,
It starts from page 24, my lord.
oh, 24.
Yes, correct. This is the order, judgment and order dated 24/3/2025, my lord. My lord, may I take my lord to page number 36,
See,
where the
24.
learned appellate court
Really?
has discussed
25.
page 36. The reasons why the appellate court has interfered with the
Page
papers.
36.
Page 36.
Hmm.
Para 8. I start from para 8. Heard all the counsel, perused the case, seen the impugned order dated passed by the learned so and so arising out of Title 6, granting temporary injunction in favor of the respondent. Seen that the learned court below has mentioned applied three golden principles of prima facie case, balance of convenience, and irreparable loss in granting the impugned temporary injunction order. Now, my lord, here, first paragraph says that all this golden principle has been applied. Now, latter part. Now, it is to be seen as to whether the said discretion in granting of temporary injunction or order has been exercised reasonably and in a judicial manner or not. It is observed that in the impugned order, the learned civil judge has stated that from perusal of the above, it is evident there was specific direction to the respondent number so and so regarding the applicants therein to be allowed to contest the election and other party be from participating. The report of official election observer and orders of the deputy commissioner and superintendent makes it evident that the order dated 14 so was not complied in toto by the respondent number 1. So from the above, it is crystal clear now that the prima facie case is established in favor of the applicant. Further, it is also stated that the impugned order, at the same time, it is also aware that respondents have placed themselves in the way of harm by their own doing violation of the court's order or so and so. From the above, it is observed that the learned civil judge in impugned order dated so and so stated that the respondent herein have violated another injunction order dated 14/1 of another miscase number. In order to come to the decision of prima facie case being made out by applicants in order to grant impugned temporary injunction order. In addition, it is seen from order dated so and so passed by the learned in this case entitled suit number with regard to the allegation of the violent said injunction order dated by respondent said miscellaneous application file under order is already pending before the court. My lord, here I pause for a while. Because for violation also, another proceeding, not by this petitioner number 2 and 3, but order 39, under order 39 2A, my lord. This another proceeding is also filed. That is for the punishment. Because under order
Before, that one was before,
before the same judgment.
before same judgment.
Same judgment. Because now it is these two proceedings are quite different now. Here I am challenging the impugned election result. And that this miscase 39, that is for my lord, violation of the court order for the punishment. That is as provided under order 39 rule 2A. My. So these two proceedings are completely different. My. Now, this court is aware of the principle of law that the contemner violator of an order of a court should not be allowed to enjoy or retain the fruits of this contempt violation. However, the fact that the appellants have violated or not the injunction order dated has to be decided after conducting a summary trial in the same suit by hearing the other side and recording of evidence as per provision of Order 39 ruled by the learned court below. Thus, stating that the injunction order dated is violated by the respondent here in the interim order dated so and so would amount to predetermination of the alleged violation of the said injunction order dated so and so. And additionally, coming to the decision that a prima facie case is made out to grant temporary injunction in favor of the defendant on the basis of the said predetermination, in the considered opinion of this court cannot be considered as just and reasonable. Now, what the learned appellate court is saying that coming to the conclusion, evidently, to make out the prima facie case, learned trial court is saying that it is evident on the record that the court's order has been violated because it is supported by the materials that prima facie opinion has to be made out. Otherwise, madam, how the prima facie case is to be made out? Now, the learned appellate court is saying that you have predetermined, madam. Learned trial court has, my lord, I have already read the order, madam. Learned trial court has not predetermined any, not decided. Learned trial court has said only, it is evident from the record that the order has been violated. And therefore, there is a prima facie case to go for a trial. Now, without coming to that prima facie satisfaction, madam, how the suit even notice can be issued, madam. So, here where the learned appellate court has misdirected herself, saying that in the misapplication itself has already determined. That issue is still pending, madam, where the learned appellate court has misdirected and has very erroneously came to this reasoning, madam. Thereafter, madam. Para 10, madam. From the above, it is the considered opinion of this court that the learned civil judge Dinaripia aid in law by stating, predetermining that the injunction order dated so and so is violated by the respondent here. Therefore, prima facie case is made out to grant temporary injunction in the interim order dated so and so. Hence, this court is of the considered opinion that the order dated 28 so and so is not just and proper and needs interferences. Accordingly, the order dated so and so is set aside and so and so. Now, my lord. Now, what is the, my lord, wrong committed by the learned appellate court? My lord has already seen the reasoning, my lord. The reasoning is that appellate court is saying that already predetermined. My lord has seen that it is question of predetermined does not arise at all. That is only to find out the prima facie case, my lord. Because something has to be made out, strong prima facie. Now, my lord, my grounds of revision is that first, my lord, the learned appellate court has committed jurisdictional error. Why, my lord? The learned appellate court has exceeded its jurisdiction, my lord. Because, my lord, in an appeal against temporary injunction by substituting its own discretion, my lord, that is not permissible under the law, my lord. The discretion of the learned trial court cannot be substituted by the appellate court when there is a supporting materials or evidence in supporting the conclusion arrived by the learned trial court, my lord. Therefore, my lord, the order passed by the appellate court is arbitrarily, my lord, capriciously, perversely, my lord, because this is completely against the settled proposition of law, my lord. Now, my lord, second ground. Learned appellate court has miserably failed to consider the material evidence. What are the material evidence, my lord? I have with me, my lord. My lord, the first material evidence, my lord, that repeatedly there are several courts orders whereby saying that allow them to participate. Thereafter, my lord, official elections observer report is saying that court's order were not obeyed, they were not allowed to participate, my lord. Second, my lord, there is a multiple orders issued by the deputy commissioner, superintendent of police, my lord. That is on the record, my lord. I have brought on the record, my lord. And these all are sufficient evidence, my lord, to make out a strong prima facie case indicating that apparently the court's order were violated. And in violation, the election was held, and because of it, this election result is materially affected. Now, my lord, very interesting. Now, may I take to, my lord, to the order. My lord, when this respondent approached this honorable court against, because initially the learned appellate court refused to grant their stay, my lord. I'll just refer that order, my lord. Page number 1095, 1096. 1095. Hello, kindly to page 1096. Nice. Second paragraph. This is the initial order passed by the same appellate court, refusing them to stay order, refusing granting the stay order, initial part. 1096.
Same court.
Madam, same court, 10/2/2025. Here, madam, may I just read the second paragraph? Heard both the peruse the impugn order dated, seen that in the impugn order dated, learned civil judge has relied on the golden principle, that is prima facie case, balance of convenience, and irreparable loss for ground of impure injection. Accordingly, at this stage, this court is of the considering affidavit sufficient cause is not met for out to grant stay to the impugn order. Well, already appellate court, my lord, in this impugn order itself, even appellate court has said, my lord, all these principles have been discussed. The law requires that just while considering the application is to discuss about those principles and to see whether any materials is there. Coming to the conclusion, that is only to be seen by the appellate court. Now, my lord, against this order, respondent approached this honorable High Court, my lord. Then honorable High Court passed the order, my lord, in CRP, rejecting their application. I'll just, my lord, page 1097. My lord, page 1097 and relevant, my lord, paragraph 1109, my lord. One 1109. Para 17, my lord. The observation made by this honorable. It is observed that while passing the injunction order, the learned trial court had discussed the three golden principles in detail. And the learned appellate court, while rejecting the prayer for, also noted the trial court had thoroughly considered this principle. Accordingly, the appellate court observed that no sufficient case had been made out to grant the stay of the impugn order. This honorable court had also observed that the learned trial court had already discussed all this aspect, my lord, about golden three principles, my lord. And this honorable court, High Court, had rejected this civil revision application. This is for that purpose, madam.
So it was dismissed.
Yes, madam, dismissed, madam. My lord, now, in addition, my lord, my further grounds, my lord. First, my lord, jurisdictional error is there. Failure to consider material evidence, my lord. Then, my lord, that contradictory findings, my lord. Now, this honorable court has already observed that there is a prima facie case, golden principle discussed, and contradicting to its own observation. Why? Learned appellate court, in the first paragraph of the impugn judgment, says that all the golden principles have been discussed. Now, meaning thereby, my lord, the prima facie case has been made out. Now, but while dismissing, it's saying that on that basis, prima facie case cannot be concluded. That's why, my lord, this is contradictory finding. Now, my lord, my another ground, my lord, there is a erroneous legal approach. Why so, my lord? The appellate court wrongly concluded that the determination of the violation of the injunction order debtor could only be decided after a full trial under so and so, thereby limiting the trial court's power to grant interim relief. Now, here my submission is this misapplication in respect of the, my lord, order 39 rule 2A for the violation of the court's order, my lord, that is completely a separate proceeding, my lord. Here, my lord, even this petitioner number 1 is not the party in that case. Now, that is completely a separate proceeding for the violation of the court order. Now, this case, this title suit is not for the violation of the court order, but this is the case that because of the violation of the court order, election result has been materially affected by. Now, the appellate court, with due respect, the appellate court has made the observation that whether the court's order has been violated or not, that has to be separately held by way of the summary trial under order 39 rule 2A. Therefore, in this case, this cannot be done. But the learned appellate court has not taken into consideration how a prima facie case is to be determined. Now, learned appellate court has to say whether I have made out a prima facie case or not, madam. Then how a prima facie case has to be determined if this aspect is not to be discussed, my lord. Now, my lord, my further ground, my lord, the learned appellate court has failed to appreciate prima facie case. Here is, my lord, overwhelming evidence, material evidence on record, my lord, establishing a very strong prima facie case that the election was held in flagrant violation of the court order. What is more required, madam, more than that? To establish a prima facie case, to go for a trial, madam. Now, my lord,
Okay.
another ground, my lord. Public interest consideration has not been also taken. Now, what will happen, madam? Now, if we allow such thing, my lord, that such illegal action is allowed, my lord, in violation of the court order. Here is the case where public interest.
See, today it's listed for motion, so without hearing the other side,
Right.
we cannot go into the entire
Right.
merits.
Right.
So,
I am today, my lord,
we will just.
only for, my lord, interim, this stay of this, my lord, order, my lord. That's all, my lord. Thereafter, my lord, this because my lord has seen.
All the parties are represented today.
No.
Here I
I'm representing only one.
Yeah, my lord.
Respondent number 1.
Yes. Because, my lord, other respondents are not the appellant. Other respondent did not challenge. Here the respondent number 1. It is the contest between two of us.
No, but have you impleted?
I have
Have
made
you impleted
other
the
also
others?
I have implemented. I have implemented.
Then in that case, notice has to go.
Notice will go, my lord, but I am for, my lord, that interim period stay of this particular this order, my lord. My lord has seen this is very.
No, interim will allow.
This is order, my
Because
lord.
otherwise, the petition will become infructuous.
No, my lord, just stay, my lord.
No, that's what I'm saying. If we don't stay it, the petition will become infructuous.
But my
So
lord,
that
yes,
is not,
my lord,
that is not.
my lord has a power. Let's say, my lord, seeing that the order in which it is has been passed. If my lord says, my lord,
Lordship,
Yes.
it is for interim stay, then kindly hear me also. Because I am the person who is going to be affected. Case is devoid of
For a short time.
case is devoid of merit. I'll not improve my argument. What I have argued before the appellate court, I'll just pinpointedly argue on that. Case is meritless. Today
No,
itself,
prima facie is there.
my lord,
prima facie.
this is one side of the
Oh,
story.
okay.
my
My
lord,
lord.
I will conclude, my lord.
Okay. Yes, please conclude.
My lord,
We have
basic-
other matters
my lord,
also after this.
Basically, my lord, I am here today, my lord, for stay.
Mm.
Why, my lord? My lord has seen the order. My lord, at this stage, I have to satisfy my lord from the order. Is it the, my lord, appellate court has a power in this manner, my lord? My lord knows that there is a very limited power so far this order 41 is concerned. My lord is very angry. Now, my lord, appellate court has to confine only to the question Well, this is again the discretionary power. Now, my lord, appellate cannot say that I think this should be the reason.
Yeah.
Only appellate court has to confine whether the decision taken by the learned trial court is supported by any materials. This is the plausible or reasonable decision or not. And that is only the thing, my lord. Now, appellate court cannot go beyond this, saying that no, this one, only has to say that whether this is there is a material or not, my lord. With this, my lord, my lord, some few judgment, my lord. Just to show, my lord, that power of the appellate court, my lord. There are so many grounds are there. Of course, my lord, today I won't make submission. My lord, I am only here for, my lord, because public interest, why I am saying, my lord. It is something like that, my lord, by violating the court order, if somebody is allowed to proceed with them. This is a very serious matter also, my lord. Because this will give a legitimizing the illegal action. Tomorrow, what will happen? It will give the same message that anytime there will nothing happen, you get the election done, you violate order. So this element is also very important here. It is not only concern between the parties only, my. Here the institutional integrity, institutional
Okay, show
full
me
voice also
the
involved, my.
authorities.
Yeah. Yes, yeah.
Short reference I will give, my lord. Just read para 27, my lord. Just to show, my lord, what is prima facie case, how the prima facie case is to be determined. Para 27. Para 27. The labor appellate had to determine on this material whether a prima facie case had been made out by the appellant for the termination of the. A prima facie case does not mean a case proved to be held, but a case which can be said to be established if the evidence which is laid in support of the same were believed. While determining whether a prima facie case had been made out, the relevant consideration is whether on the evidence laid, it was possible to arrive at the conclusion in question, and not whether it was the only conclusion which could be arrived on that evidence. It may be that a travel considering so and so. Now, my lord, what is this saying? The prima facie case is that, my lord, whether if the evidence is laid in support of the statement made there, if it is believed, my lord, and whether the case is made out or not. Here is the case, my lord, that violation has been said, my lord. Now, my lord, this Dalpat Kumar 1992. Right, 1990. 1991 SCP 719. I'll soften my argument, my
Yeah,
lord.
para.
I'll just read para 5, my lord. Those other are important. This is most relevant. That's why I will cut other paragraph, para 5. Therefore, the burden is on the plaintiff by evidence or otherwise that there is a prima facie case in his favor, which needs education at the trial. The existence of the prima facie case rather than infraction of his property or the right is a prima facie case is not to be confused with the prima facie title, which has to be established on evidence. Only prima facie is a substantial question raised, bona fide, which needs investigation and decision on merits. I'm referring, my lord, that the issue raised by me before the landed trial court, that court's order has been violated, election has been lost. It needs adjudication. A strong prima facie, sufficient evidence I've laid. Then in the initial state, that is only the standard that has to be fulfilled. And that has been done in my case, and the learned trial court has considered that aspect. Now, with this, my lord, I will just, I'll have 2 more judgment, then I will conclude my argument. My lord, kindly turn to 1991. 1990, supply, SCC 727, power of the appellate court. 1990 supply, SCC 727. Short paragraph, my lord, para 13 and 14. What is the power of the appellate court, my lord?
Para?
Para 13 and 14, my lord. On consideration of the matter, we are afraid that the appellate bench fell into error on two important propositions. The first is a misdirection in regard to the very scope and nature of the appeals before it, and the limitation on the powers of the appellate court to substitute its own discretion in an appeal preferred against a discretionary order. The second pertains to the infirmity of the ratiocination as to the quality of sewage, 14 correct. The appeal before the division bench were against the exercise of discretion by the single judge. In such appeals, the appellate court will not interfere with the exercise of the discretion of the court of the first instance and substitutes its own discretion, except where the discretion has been shown to have been exercised arbitrarily, capriciously, or perversely, or where the court had ignored the settled principle of law regulating grant or refusal of the interlocutory injunction. An appeal against exercise of discretion is said to be an appeal on principle. Appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below. If the one reached by the court was reasonably possible on the material, the appellate court would normally not be justified in interfering with the exercise of discretionary under appeal, solely on the ground that if it had considered the matter at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that appellate court would have taken a different view may not justify interference with the trial court exercise of discretion. This is basically the settled principle of law, that the appellate court cannot substitute its own discretion. The appellate court should have only confined whether this finding by the learned trial court about the prima facie case violation of the court order, whether it is supported by any material source. Only that should have been decided. But completely substituted on discretion, and the issue which is not there is that predetermine everything. Nowhere learned trial court has predetermined. It said that evident prima facie. With this, I will conclude my prayer is, since
To state
he has been restrained earlier since long time. Only recently, because of this impugn order, only now again functioning. So my humble prayer, this impugn order may be stayed and earlier trial court order may be allowed to function. So far, if this is stayed, automatically that will be there. This is my humble prayer.
Since Lordship, I have filed caveat, so I should be also given
Yes, yes.
opportunity.
I
before
will hear
passing.
you. Respondent one, na?
Respondent number one, against me, my lord,
Yes.
there was an injunction.
Yes.
Lordship, I'll not improve my argument. What I had argued there at before the appellate court, same argument, the written argument I have, which I have submitted on record. If LCR is called tomorrow, definitely that will also come. Here in this case, Lordship, the title suit number 21 of 2024 is the outcome of title suit number 17 of 2024. In title suit number 17 of 2024, my lord, I am non-suitor. I am not party in that suit.
Title suit
Number 17 of 2024,
17 of 24.
wherein some ad interim injunction order it was passed. And that is now saying that those injunction order it was violated. I am not party to that suit. Lordship,
Okay.
the written argument that I have placed on record before the learned appellate court, I believe after going through this, Lordship would be clear about the case. Kindly come to page 1. May I start?
Yes.
This is memorandum of argument that the appellant is a democratically elected president of all Nishi Student Union in short ANSU in the recently concluded 16th General Conference cum election ANSU 2024 held at Itanagar for a period 2024 to 2027. That the respondents as plaintiffs brought a suit against the appellant and pro forma respondent in the Court of Civil Judge Junior Division UPA being title suit number 21 of 2024. Lordship. Praying for following reliefs. Declaration that the ANSU election 2024 by which the appellant has been declared as president of ANSU for a term so and so is illegal and void. Second, for coercing the impugned election result notification dated 29/11/2024 for the election of appellant, leaving aside, Lordship, kindly this may be also taken note of, leaving aside other 25 elected executive body who too have been declared elected by the same notification and who have not been made party in title suit number 21 of 2024. Now, prayer number C, Lordship. Order directing for holding a fresh election for the post of President ANSU as per ANSU Constitution after complying with the injunction order dated 14/11/2024 passed in title suit number 17 of 2024 pending in the Court of Civil Judge Junior Division. D, and for permanent injunction against the appellant who was a dependent number 10 in the suit, restraining him and the representatives from claiming and acting as president of ANSU or from using the power, seal, and signature of the president on the basis of impugned election result. The pro forma respondents who were the election team constituted for conducting election arrayed as dependent number 1 to 8 in the suit. Pro forma respondent number 9 was the ex-president of ANSU and was arrayed as dependent number 9 in the title suit. The appellant is arrayed as dependent number 10. So this entirely, Lordship, it talks about title suit number 21 of 2024, the latest one, wherein I have been given injunction, Lordship. Now, kindly come to paragraph 3. That the respondents plaintiff, along with the suit, had also filed a petition being Ms. J case number 25 of 2024 under Order 39 Rule 1(2) read with Section 151 of CPC. They were seeking temporary injunction for suspending the operation and effect of impugned election result by notification dated 29/12/2024, issued by the dependent number 1 and 2, who are the election of the appellant as president, for restraining the appellant dependent number 10 from representing himself as president of ANSU or using seal, sign, emblem of ANSU and exercising the power and function of the president of ANSU. Number 4, that the main contention of the plaintiff in the suit is that the crux, the dependent number 1 to 8 in this TS number 2021, Lordship, kindly that may be taken note of, dependent number 1 to 8, being the election team, has conducted the election in violation of the injunction order dated 14/11/2024, passed in Ms. Case J number 18 of 2024, arising out of title suit number that another one 17 of 2024, Lordship.
You were not a party.
I am not a part. I am non-suitor, Lordship. Now,
This was against the election commission.
against the election commission. Now, against the election commission, they have violated the injunction order. Why should I be punished, Lordship? No, let me read entirely, Lordship.
Okay.
Now, the said title suit number 17 of 2024 was filed for seeking setting aside and questioning of notification dated 19/11/2024, issued by the dependent number 5 and 6, chairman and vice chairman of Electoral Enroll Committee constituted for ANSU election 2024, by which the dependent number 5 and 6 alleged to have excluded the plaintiffs and the recommended delegates from participating and vote in the election and approved a list of candidate of BSU unit, namely APCG-TSU, recommended in the various posts by 2 persons, namely Rei Taha and Gokia Tayum as APCG-TSU members, which according to plaintiffs was illegal. The plaintiffs further contended that had the dependent number 1 to 8 allowed the candidate of the plaintiffs and disallowed the candidates of the rival party in pursuance to the injunction order dated 14/11/2024, the plaintiff number 1 could have won the election as president of ANSU. Hearing what Lordship it says, had that order dated 14/11/2024, Lordship has already gone through that order, that interim order. Had that been given effect to, then this petitioner number one,
He could have won.
he could have won the election. Now, in subsequent title suit number 21, 24, this petitioner number one, Lordship, he enjoined as a plaintiff with plaintiff number 2 and 3, who are the plaintiff in title suit number 17 of 2024. I believe Lordship is getting me. Lordship, this petitioner number one, the Ashok Doka,
Present.
petitioner number one, he is also not a party in title suit number 17 of 24. He has enjoined the plaintiff petitioner number 2 and 3 in the subsequent title suit in 21 of 2024.
He's not
Because
the party
he-
also in 17 of 24.
17, he is not party. He is also not party. I am also not party. Both of us, we contested the election for the post of president. And the election, it was held democratically. It was live telecasted. I won. He was defeated. Now, Lordship, the plaintiffs further contended that the dependent number 1 to 8 allowed the candidate of the plaintiffs and disallowed the candidate of the rival party in pursuance to the injunction order that the plaintiff could have won the election as president of ANSU, and he could have not faced defeat in the election by the margin of 91 votes with the appellant if dependent number 1 to 8 prohibited dependent number 13 to 63 from participating in the election who might have voted in favor of appellant. So this is, Lordship, kind of assumption. Had it been that order it was complied, given effect to, then those 51 delegates, Lordship, might have voted this petitioner number 1, who contested the post for the president ANSU, Lordship. This is the basically case. There was a violation of order dated 14/11/2024. That is the cause of action, Lordship. The violation of order dated 14/11/2024.
That was in title suit 17 of 24.
Correct, Lordship. In a miscase, that interim order it was passed, and that violation order become the cause of action for this title suit number 21 of 2024, Lordship.
Of 24, and that became the cause of action in which cause of action in- the second one is title suit
Number 21 of 2024, Lordship. And
then
why?
in 21 of 24 you are party.
Yes, I am party. I am dependent number 10, Lordship. And in that plaint also, Lordship, very interestingly, in entire pleading, there is no any whisper or any allegation that I have in connivance with other election team have done or I have violated the order passed by the civil judge junior division, Lordship. Completely, absolutely silent. That is admitted fact, Lordship. I am coming on that also. In this argument, it is there. Now, paragraph 5, Lordship. That following reliefs are prayed for by the plaintiff number 2 in title suit number 17 of 2024. Now I am coming to title suit number, Lordship, 17 of 2024. Herein, I am not party and petitioner number 1 is also not party. In that case, the prayer is, Lordship, for declaration that the plaintiffs have civil right to participate and contest and vote in the ANSU elections 2024. This is one of the prayer. Number 2, declaration that the dependent number 9 to 12 have no right to represent the BSU, namely APCG, TSU. Number C, mandatory injunction direction to dependent number 1 to 8 to allow the plaintiff to participate, vote and file nomination and contest in the election. Number D, mandatory injunction directing the dependent to not allow the dependent number 9 to 12 and their delegates and recommended candidates to participate in the ANSU election 2024. This was the prayer, Lordship, in title suit number 17 of 2024, wherein, Lordship, I am non-suitor. as well as the present petitioner number 1 is also not party. Now, paragraph 6, Lordship. That the learned court below bide at interim injunction order dated 14/11/2024 passed in Ms. J case number 18 of 2024. This is Lordship in title suit number 17. Had suspended the operation of the aforesaid two notification dated 9/11/2024 and notification dated 12/11/2024. However, the learned trial court directed the dependent number 1 to 8 to allow plaintiff number 21 to 24 to file their nomination in the ANSU election and prohibited the dependent number 9 to 12 and dependent number 13 to 63 from participating in the election. Although no prayer was made in the main suit, being title suit number 17/2024, to prohibit the dependent number 13 to 63 from participating, voting, and contesting the ANSU election. Paragraph 7, Lordship. That the appellant and pro forma respondents thereafter on being summoned in title suit number 2020 or subsequent one appeared in the case and contested the case by filing their written statement and written objection in the petition, being Ms. J case number 25 of 2024 for temporary injunction, denying various allegations made in the case against them. Kindly, this may be taken note of, Lordship. In this title suit number 21/24, wherein I am injuncted, the other election team also, they have filed a written statement denying that no, we have definitely not violated the order of court as well as district administration. That written statement already it has come. That's why Lordship, this has become voluminous, this appeal petition. The dependent number 1 to 8 being the election team constituted for conducting election in their written statement denied to have violated any order passed by the court and authorities. It was part of contention of the dependent number 1 to 8 that they allowed the plaintiffs to participate in the election as directed by the court, who were found present in the election hall, and restricted the candidates to vote in the election as directed by the court. The entire voting process was live telecast in the electronic media for maintaining transparency in the election. Moreover, the plaintiffs in the case have failed to show any prima facie proof to show that the persons who were prohibited by order dated 14/11/2024 were allowed to vote. The appellant, by filing his written objection, amongst other, objected to grant of any temporary injunction against him as he was elected as president. Appellant means me, Lordship, as a dependent number 10. I have also filed a written statement. Was elected as president by the democratic process of election. Since the injunction order dated 14/11/2024 was passed against the dependent number 1 to 8, the dependent number 10 appellant in no way connected with the violation of injunction order dated 14/11/2024. And if temporary injunction is granted, he will suffer irreparable loss and injury as he has been functioning his duty as president with utmost sincerity for the welfare of the student fraternity. So this was my written statement, Lordship, before the trial court. Now, paragraph 8, Lordship. That the respondent plaintiff had also filed a petition under Order 39 Rule 2A. Now, this is in title suit number 17, Lordship, for violation of injunction order. The respondent plaintiff had also filed a petition under Order 39 Rule 2A, which was numbered as Ms. J case number 39 of 24 in title suit number 17 of 24, praying for drawing an appropriate proceeding and punishment against the dependent number 1 to 8 in the case for alleged violation of the injunction order dated 14/11/2024, making Deputy Commissioner and Superintendent of Police Itanagar as party dependents. The learned court has already issued notice to the dependent number 1 to 8, pro forma respondent number 4 to 11 by order dated 9/12/2024 as the injunction order dated 14/11/2024 was passed against them, not against the appellant. This respondent number 1 also. The said suit number 17 of 2024 in Ms. J case number are pending for adjudication now. Now, paragraph 9 also.
17 of 24 is still pending.
It's still pending also. Now, paragraph 9 also. That the learned court below, after hearing the applicant and respondents, has passed impugned order dated 21/1/2025. That is the first order, Lordship, wherein I have been injuncted. In Ms. case number 25 of 2024, granting temporary injunction in favor of the respondents thereby suspending the operation of election result, restraining the appellant from representing himself as president of ANSU for 2024 to 2027, restraining him from exercising the power and function of the president and using any sign, seal, emblem, or any other symbols of the office of ANSU till disposal of the main suit. So these are the facts, Lordship. And now, coming to my memo of argument before the appellate court, Lordship. Kindly let us start from Roman 1, Lordship. There are certain admitted facts, Lordship. Roman 1, Lordship. Admittedly, Lordship, the bylaw of ANSU says the appellant Lijan Gyati is eligible in all aspects to contest and hold the post of President ANSU. Why this is, Lordship? Because bylaw doesn't bar me from contesting or holding the post of ANSU. This is only because of violation of some court order by some other person. I have been injuncted. Otherwise, I am eligible. So therefore, this is admitted fact, Lordship, that I am eligible to contest and hold the post in all aspects, Lordship. Roman 2, Lordship. Admittedly, no allegation in the plaint is made that the appellant Lijan Gyati has violated the interim orders of learned trial court or stroke DCICR stroke SPICR, Lordship. In the plaint, absolutely silent, Lordship. No whisper that I have by any means violated the order or I have in connivance with the election team. Nothing as such is there. Number 3, admittedly, no allegation in the plaint is made that the appellant Lijan Gyati has paid any money to the voters to manipulate them in his favor. It is also absent. Number 4, admittedly, for violation of interim order dated 14/11/2024, an application under Order 39 Rule 2A has been filed by Miss Case number so-and-so, which is pending for trial, taking necessary evidence, and next date is fixed on so-and-so. That also I have mentioned, Lordship. 5, admittedly, the impugned order dated 28/1/2025 was passed basically on the ground that the respondent number 1 to 8 have violated the interim order dated 14/11/2024, violation being dispute and pending trial in Ms. J case number so-and-so. Why I have said this, Lordship? Because the first order wherein I have been injuncted, Lordship has read that order also. Therein, respondents have violated the order, respondents have violated the order. In some of the paragraphs, it is mentioned, but then that is not me, Lordship. That talks about other election committee members, those who are alleged to have violated the orders, Lordship. Otherwise, I can later on come to that order, Lordship. So, Lordship, Roman 5.
So you just tell me in title suit 17 of 2024,
Lordship.
who were the parties?
This petitioner number 2, he is plaintiff.
Petition number 2.
Yes, 3 is also plaintiff.
Wait, okay. 2, 3. Because you are saying that petitioner 1 is also not a party, you are also not a party.
Correct,
In
Lordship.
17,
Lordship, may
24.
kindly come to page 272. 272, Lordship.
In this one,
272,
2.
Lordship. This is the title suit number, Lordship, 17 of 2024. And party's name starts from, Lordship, page 275. 275, Lordship. Down below, post title. Number 1, B.T. Tanya. He is the petitioner number 2 herein. Next page 276, page number 276. Plaintiff number 2, Sri Gokia Tame. He is the petitioner number 3 in this case. And rest 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24. So other,
They are all here in this.
no, in this case, they are not here.
So here only this petitioner number 1, 2, and 3 are there.
One, he recently in the title suit number 21, he enjoined is because he contested the election. And he's saying that had those court orders it was given effect to, then I might have won the election. That is the case in plain.
Then the respondents were Chief Election
Ah,
Commissioner.
Respondent 1 is there with us in this case, 2 is there, 3 is there, 4 is there, 5 is there, 6 is there, 7 is there, 8 is there, and rest are not there in the title suit number 21, 2024. Up to 8, possibly. Up to 8.
So all election committee, electoral enrollment committee, secretary, vice chairman. Yes, please continue.
Okay. So Lordship, after Roman 5, 5 I have read out, Lordship,
Yes.
wherein I have said that basically the injunction that was given to me on 28/1/2025 was passed basically on the ground that respondent number 1 to 8, they have violated the order dated 14/11/2024, not me, Lordship. Now 6, Lordship. Admittedly, learned trial court below has not found even prima facie that appellant Legend Gaddy has violated the interim order dated 14/11/2024. Pleading silent, Lordship. Even in the first injunction order 28/1/2025, that can be read it out repeatedly also, Lordship. There's no any finding that I was involved there in violating the order of the court, Lordship, court below, Lordship. Now, Roman 7, Lordship. Admittedly, in title suit number 21 of 2024, that subsequent one, wherein the connecting application injunction order dated 21/2025 was passed, the second prayer B was for quashing of impugned election result dated 29/11/2024, qua the election of appellant, and prayer number C was for direction for holding a fresh election for the force of President Ansu as per Ansu Constitution of after complying with the interim order dated 14/11/2024 passed in title suit number 17 of 2024, pending in title suit number Civil Judge Junior Division UPR. Now, Lordship, just I pause for a moment. If suppose I make a prayer in my plaint that such and such notification, that notification being consequently come out of the violation of some court order, that may be nullified. If that is my first prayer, then my second prayer, Lordship, I am saying that after nullifying that, let there be a fresh election. So meaning thereby, Lordship, the plaintiff, how do he have a prima facie case also, Lordship? If suppose, Lordship, had it been after nullifying that order, immediately I was restored to that post, then of course there will be a prima facie case and balance of convenience, irreparable injury. Nothing is there. Because what is the prayer in the suit is that first you nullify this election result, thereafter please hold a fresh election. Who will win that election? No one knows, Lordship. Thereafter permanent injunction, Lordship. If in such cases, Lordship, if injunction is granted, that too admittedly in the plain democratically got elected with 5,897 voters, Lordship. Not justified. Therefore, we had to file appeal, Lordship. Now, Lordship, paragraph 8, page 8, in continuation that just I have made some submission. What if the FREER number B is decreed holding that the interim order dated 14/11/2024 was violated and therefore the election result dated 29/11/2022 is invalid against the appellant? It will be followed by a fresh election. And if plaintiff wins the election, then only he will have a right that will be of legal character as defined in Section 34 of the Specific Relief Act 1963 to approach the court by invoking the provisions. As on that, he has no any right to not to talk about legal character right for which he is entitled to any temporary injunction under the facts and circumstances of the case. Because I have narrated the example also. Firstly, that will be nullified. Thereafter, there will be election, even if it is decreed also. On the assumption that had that 51 delegates voted, I might have won. What is the case, also? And those, had it been those 58 delegates also, they come along with them as a plaintiff, saying that we have not been allowed to vote. Then also, case would have been different, Lordship. And now, Lordship, also if the prayer number B is decreed, holding that the interim order dated 14/11/2024 was violated, then all the other executive body, 25 in numbers, who to got the vote shares in violation of the interim order dated 14/11/2024 would be affected, and therefore they are prominently necessary party to the suit, and admittedly they are not being made as a party. Here also, Lordship, again, another interesting thing. Now they are saying that our 51 delegates were not allowed to vote, but other parties, 51 delegates, they were allowed to vote. Therefore, this should be nullified. If other 51 delegates voted, they will not vote only to the post of president. They will be voting for the post of president, vice president, secretary, all 25 executive bodies. So if tomorrow, what will happen? If suppose trial court below hold that there was a violation of order dated 14/11/2024, therefore this result nullified. Are the other executive body not going to be affected by that order? Definitely they will be affected, Lordship. Therefore, we have in our written statement also, we have said here necessary party. Even suit is defective, Lordship, to my humble understanding to law, Lordship. Now, 8, Lordship, admittedly the appellant participated in the election. The margin votes are 91 in between the plaintiff number 1 and the appellant, and the democratic voting process has been completed. 9, admittedly no substantial rights that is of legal character is with the plaintiff number 1, that is the who contested against me, petitioner number 1 in this case, who lost the election to the post of President Ansu. Where is the right for seeking injunction against the democratically elected President Ansu? That is my observation. Admittedly, no substantial right that is of legal character is with plaintiff number 2 and 3, who allege that they have not been allowed to participate in the election process in terms of interim order dated 14/11/2024. Where is the right for seeking injunction against the democratically elected President Ansu? 11, admittedly, the last prayer number D in the plaint is for permanent injunction against the appellant, restraining him and his representative from claiming and acting as president of Ansu or from further using the power, seal, and signature of the president on the basis of impugned election result. And the learned trial court below has partially decreed the suit prayer number D without adjudicating the rival claims of the parties by the impugned order dated 28/1/2025. Why I have said so, Lordship? Because by injuncting me, had it been, he was allowed to function, the petition number 1, then at least, Lordship, for the interest of his student, someone will be representing the Ansu as a president. He is out. Now, on some assumption, he get injunction against me, Lordship.
Even then, he won't function as president.
No, if injunction is granted,
Because he's not elected.
Lordship, if I am injuncted, Lordship, then I'll be not functioning, Lordship.
No, he is not elected. That's what I'm trying to say.
That is why, Lord, I'm also on that context only. Had it been the case, Lordship, granting me injunction, had he was allowed to function, Lordship, at least for the interest of the student. But here in this case, he is out and then he has filed title suit. I was democratically elected with such large numbers of votes, Lordship. And then on the assumption that had those 51 delegates were allowed or given a court order given effect to, then I might have won the election. On the basis of that assumption, how could, Lordship, I be injuncted, Lordship? So therefore, I have narrated those lines, Lordship. Now, 12, Roman 12, admittedly, there was no statement in the plaint as to how non-granting of temporary injunction would cause irreparable loss to the plaintiffs, neither a statement with regard to the balance of convenience, except allowing the appellant to enjoy the fruits of the illegal acts by prejudicing the rights of the applicants would be travesty of justice. And therefore, the learned trial court also given the reason that, and as admitted by, so Lordship, this is on considering the observation that are made in the impugned order 21-1-2025. Admittedly, Lordship, there is no any narration or averments, plain as well as in this case, that if such injunction is not granted, then what will be the irreparable loss that this petitioner number 1 is going to sustain? Leaving aside 2 and 3. 2 and 3, they are not interested in my post. Only 1. And how is the balance of convenience, Lordship? Because, Lordship, at least while exercising the discretionary power, Lordship, under Order 39, Rule 1 and 2, balance should be weighed, Lordship. If I grant injunction, if I deny injunction, who is going to be irreparably sustaining injuries? In this case, had not granted also, Lordship. He is, I mean, in no connection he is going to be get injured or irreparable any kind of damage, Lordship. But injunction, granting injunction, that to after being elected with election result and that live telecast, Lordship, with such large number of margin of voters, Lordship, if I am injuncted, definitely, Lordship, this is me who is going to be affected or sustain irreparable injury, Lordship. So thereafter, Lordship, I have categorically submitted law points on each and every aspect. Here, all the judgments are here only, Lordship. From paragraph 11 onwards, this is the copy of the memo of argument that I submitted before the learned appellate court. And tomorrow, if LCR is called for, this will come along with the records, Lordship. I am on records, Lordship. So here, Lordship, therefore, last paragraph, I have said that with the aforesaid admitted fact, it is respectfully submitted that the impugned order is arbitrary, perverse, non-application of mind, unjustified, unreasonable, and not sustainable in the eye of law and liable to be set aside and quest. Submission on law points 11 that the Honorable Supreme Court in case number Supreme Court Bar Association versus so and so has held that the injunction should not be in the form of decree partially without adjudicating rival crimes of the party. Para number is given, Lordship. 12. That the Honorable Delhi High Court in the case of Lalit Kumar Modi versus BCS reported in 2013 SSC Online Delhi has held that while granting injunction as to how the party is going to suffer irreparable loss, which cannot be compensated in terms of the money, has to be explained with reasons, and the non-giving of the reasons shows complete lack of application of mind. Para 12. See? Now, Para 13, that the Honorable Supreme Court in the case of United Commercial Bank of India reported in 1981 so and so held that the High Court had not touched upon the question whether or not the plaintiffs would be put to irreparable loss if there was no injunction granted. Para 50 to 54. Now, paragraph 14, that the Honorable Bombay High Court in the case of Kishore Bajaj and so reported in 1980 SSC held that assuming that the plaintiff has made out a prima facie case, still the court cannot grant an injunction if on the other two counts, the plaintiff has no case whatsoever. Other two counts is lordship, irreparable loss and balance of convenience. 15, that the Honorable Guwahati High Court in the case of Sri Arjun Chandra Das so reported in 1995 SCC online Guwahati has held that in the absence of necessary party being not impleaded in the suit, the temporary injunction could not have been passed. Para 9. Case 12, that the Honorable High Court Goa, Daman and Diu in the case of so reported in 1971 SCC online held that for granting temporary injunction restraining the return candidate from discharging his official duty attached to the post which he owned is not maintainable under Order 39, Rule 1 and 2. This also I have submitted. And following the same, the Honorable Madras High Court in case of MJ&T 2012 to SEC Online Madras 3607 has held that there cannot be injunction restraining the elected return candidate from functioning till disposal of the suit. Order 39, Rule 1 and 2 are not attracted. So under apostate facts, and lastly, one more judgment, Lordship, kindly come below, down, NB.
2000.
Herein 2006-5 SCC, para 30 and 33. Herein ratio, Lordship, number 1, the requirements for granting temporary injunction, that is at para 30. And what are arbitrary, capricious, and perverse that are discussed at paragraph 32, Lordship. And this is the judgment wherein it is held that if it is found by any means within that circle, like arbitrary, capricious, and perverse, that is para 2, then appellate court can definitely interfere, Lordship.
These are the judgments.
These are the judgments. So therefore, Lordship, and replying my learned brother, like he is shown Lordship the FIR that is at page 238. FIR. My name is not there. Surprisingly, it is against some other person. The post was not only president post, altogether 25 posts, Lordship. I have contested for the post of president, Lordship. And there are other 24 posts, Lordship. There had been like so many fighting among the groups. FIR is there, but my name is not there. And another, that observer report, Lordship,
Yes.
at page 255. That observer report also, this is one-sided report, Lordship. How they are authorized to give this report? After all, this was an election, Lords. To win the election, everyone give their best. So chances is there, Lordship, that this observer being party from some other team, they have submitted this report. And in this report also kindly, Lordship, it is completely silent again that I have played any role, Lordship. Therefore, Lordship, this revision petition, my humble understanding, is devoid of merit. And I pray for dismissal of the revision petition, Lordship.
At least let us call for the trial court reports. Huh?
LCR, Lordship.
Yeah.
Fine,
But,
Lordship.
Yes.
my lord, short reply, my lord, may I make
Yes,
a
yes,
short
okay.
reply.
Yeah.
My lord, sure. My learned friend's argument and again is saying that he has not violated it. My case is not that whether he has violated or this is not the contempt case. Case is that here is an order from the court that
No, no,
election-
but you have to first establish your right, no?
Yes, yes,
Mm.
that's why, my lord.
Yeah. So, even if the interim order is granted, doesn't mean that you will become the president.
No, no, my lord.
You are not even elected.
Yes.
Fresh elections you have prayed for in the Dalits.
Yes, my lord. That's why I'm coming, my lord. Here there is case,
So
the
it
judgment, my
doesn't
lord, I
affect you
will.
at all.
Yes,
Yeah.
Supreme Court have repeatedly saying that anything is done in violation of the court order is non-exist. I will show the judgment.
No,
That's-
okay, that is
that's why-
fine. That is
that's
on
why,
the
my lord.
merit. But today I'm only on the interim.
That's why. my lord.
Today I'm only on the
Interim,
interim.
That's why. my lord.
Yes.
here is the case, my lord is not sitting as a appellate court. My lord is sitting here as a revisional. My lord, revisional jurisdiction is limited to the extent where the appellate court has exercised its power within its limitation or exceeded the appellate power. My lord will see the order passed by the learned trial court is whether it's the most recent order or whether the appellate court, whether my lord, this order, impugn order I have just read it out. The appellate court, whether has confined within the power of the appellate, my lord will determine that because my lord will not substitute any opinion about the.
No,
thing.
definitely
I will
not.
only see. Now, what I have to do now is to satisfy my lord prima facie. This appellate court order, my lord has seen it.
Yes.
What is this order, my lord? But can we allow this order to sustain? My lord has seen the order passed by the learned trial court is the most recent order. All aspect has been discussed. Now, my lord, now can appellate court say, well, is it something, who has the discretionary power? Appellate court has no discretionary power. Appellate court has to only see whether the reasoning or decision given by the trial court is supported by the materials or not. Once it is done, repeatedly Supreme Court is saying, our High Court is saying, appellate court, because my lord, this is not a regular appeal. My lord, we are not going deal the issue which is right, wrong. This is
No,
not
no,
a
no.
regular appeal. Appellate court is the appealing
Yes.
principle.
Yes.
My lord. Now, my lord, what is the, my lord, apex court is saying, my learned friend is repeatedly saying that I have not done chanting. Why should I suffer? Please hear. When I put some example. Suppose the honorable court passes a order. Don't construct a building. Suppose to one person. Now he has constructed. Now tomorrow can other person can say, no, since I have not constructed, I can use it. So I have not done anything. No. Judgment says that third party interest cannot arise. Anything. But once the learned trial court has made out a prima facie satisfaction that it is evident that the election has taken place in violation of the court order and it has materially affected the election. Once that finding is there, prima facie it is supported. Strong prima facie case is there, my lord. Where is the position of my lord appellate court coming to a different conclusion, my lord, that to the on the basis of very erroneous approach, saying that predetermination has been done. That is only the reason, my lord. My lord, we confine only to the issue whether the appellate power has been properly exercised. So this is the case, my lord. I have, my lord, my humble submission is that I have prima facie, my understanding, my lord definitely will take a call that this is a case ordered by reading the impugn order at the plus itself, my lord. It is so clear that it has exceeded its appellate power and it's not a reasonable order, and the order passed by the learned court is the learned trial court is the most reasonable. And the my lord is sitting as a revisional court, my lord will only see whether the discretionary exercise by the learned trial court is rightly done or not, or whether the appellate court was rightly interpreted or not. With this submission, my lord, otherwise, why this urgency, my lord? The matter, my lord, here, once it's continued to function, matter will become infructuous. What is the use of, my lord, even if I accept the argument, then what will happen? You violating court order, you do anything, then nobody can restrain
No,
you.
but does it benefit you in any way?
No, here is the
That's
question
the
of benefit, my lord. Here is the issue. Whether
And
he has a right
union-
to represent my benefit is not whether he has a right to represent by violating the court order, the election that has taken place.
No, that election, it was against the election commission.
Right.
That the vacation, that order
Right.
was against the election commission, not against him.
No, that's why, my lord. Because election commission has violated the order. That result is enjoying it.
No, that issue is already there pending before the trial court.
Trial court.
Yes.
That's why learned
They
trial
will
court,
decide
that's why-
whether the
that's why-
election
Today,
commission.
my brother and me will
My lord.
swear on, let us take place that we will expedite the case before trial court. We will expedite.
See, it
My
will-
lord, one second. That's why learned trial court has said, it is evident, prima facie satisfied, so many materials are. My lord, once that's sufficient, that conclusion is derived. My lord, whether the appellate courts overruling that conclusion is proper.
I think I've heard you very patiently.
Fine.
Okay,
Fine.
so let the court decide now. Item 3, okay. I've heard learned counsel for the petitioner, Shri R. Sonar, and learned counsel for the respondent number 1,
Okay, tamam, madam.
K. Tama. I will pass the order in the chamber. The matter is. You see that it's a research and order will be passed by the judge. I have to go through too many
Right.
documents, so just bear with me.
My lord.
Deeply obliged.
Not result, today's date only. Give me a separate.
Lordship, this is bail application for release of the arrested accused person in connection with alert circular number 1 of 2024-25 under section 132(1) B and C of CGFT 2017, Your Honor.
Hmm.
Your Honor, by order dated 3/2/2025, the accused were arrested in the present case.
Hmm.
Now, thereafter, what happened? Under 132 of CGST, GST Act, the punishment is extendable up to 5 years. So, in terms of section 187 CR BNSS,
Hmm.
the limitation period would be, the mandatory period would be 60 days for detention of the arrested accused person.
Hmm. 60 days.
60 days,
Since
because punishment
punishment is up to
up
5
to
years.
5 years, extendable up to 5 years. Now, accused was arrested, detained from by the order of the executive magistrate, magistrate first class from 3/2/2025.
3 to
2025. Now, 60 days ended on 4/4/2025 laws.
4, 4, 2.
Now, on lordship, 3/4/2025,
Hmm.
the CGST authority, they file a fresh complaint, being criminal complaint case number 26 of 2025 against the accused person before learned JMFC UPN.
Hmm. Hmm.
Now, what happened? That criminal complaint has been treated as charge sheet under 187 CRPC, and the default bail filed by the accused person was not entertained. And till today, lordship, the accused person is detained under custody.
You had
Since-
filed when the default bail application?
It was filed on 4/4/25.
Oh, 425. And the charge sheet
Charge sheet filed on 3/4.
3, 4.
3/4/2025 was the 60 days from the date of his arrest. But that criminal complaint that was filed under 223 of BNSS lordship, which the learned JMFC has treated it as the charge sheet.
Section
223. Lordship, of BN. This is a complaint to before the magistrate,
not check.
private complaint. 223. They have filed a criminal complaint case against the present accused person And now that complaint has been treated a charge sheet by the learned trial court. And now till today, the accused person has been detained in custody for more than 67 days. So Lordship, today, this bail application, I am praying for the release of accused person on two grounds. If they treated as a charge sheet, on that ground also, the investigation has been completed. Charge sheet has been laid before the trial court. So accused deserve to be released on bail. So Lordship, may humbly pray that matter may be fixed on 21st, I think. On
21st.
Yes, just after the break. And in the meantime, two records will be required, Lordship, by this honorable court for proper verification. The first records in relation to alert circular case number 1 of 24 and 25, where the accused person,
Where is that?
where accused person has been arrested. That is in their application, page number 59, Lordship,
29.
page 59, Lordship, Annexure 4 series. 59.
Page 59.
Yes, Lordship. 59. This is the application filed before the Chief Judicial Magistrate by the CGST authority praying for sworn arrest of the accused person in this GST case. Now, Lordship, because the accused was arrested in another cases, Itanagar PS case number, I'm not mentioning this case because on that, in that case, the accused has already granted bail.
No, but the records will be required for which one?
This one, alert circular number 1 of 24. Now the order is at the order of JMFC as page number 71, where the details of case has been reflected. 71.
71.
59 is the application by the GST authority seeking the arrest and detention of the accused person in their case. The case number is alert circular number 1 of 24 and 25. It is reflected in the top of left side, Lordship.
Okay, alert circular 1.
Yes, Lordship. 1 of 24 and 25 under section 132B of CGST Act. And by this order, the learned CGM, JMFC, allowed the arrest and detention of the accused person. From this day, 3/2/2025, the accused person was under custody of the CGST authorities.
Learned counsel.
No, Lordship.
Yes.
I'm appearing on behalf of this respondent. Yes, that may be fixed, but for the clarity
We'll
of
call for the records.
Yes.
for the CGST
Oh.
standing counsel.
Okay.
Uh,
Your CGSC.
Yes,
Okay.
CGST standing.
Oh, CGST.
Yes,
CGST.
yes,
Okay,
CGST, Central.
Standing
Good.
Council.
Yes.
Mm.
So, Lordship, for clarity, its prosecution has been charged. Charge sheet has been launched under section 134 of the CGST Act.
Mm.
So that's the procedure in GST. And read with section 10 clause 1A of BNSS and this section 2 to 3 for further procedure.
133.
134.
134. Oh, cognizance of offense.
Yes.
Okay, we'll.
Yes,
do
that's
another
one.
date.
Yes.
Learned counsel for the petition amendment, Mr. Research, bring for granting of bail to the arrested accused person, Shri Ashutosh Kumar Jha, who was arrested by the Inspector CGST and CX Itanagar Commissionerate on 3/2/2025 under section 69 of the CGST Act 2017 in connection with alert circular 01/2024-25 under section 132 under bracket 1 under bracket small b and under bracket small c of the CGST Act 2017.
Yes.
Learned standing counsel for CGST is present. Call for the records of the alert circular
1 of 24.
one slash 2024-25 from the
JMFC
from
UPI.
the JMFC UPI,
Yes,
from the court of the JMFC UPI,
along with Lordship, the criminal complaint case
along with the records of the criminal complaint case 87,
26 of 2025.
26 of 2025. Where is that?
I could not obtain the CTC,
Oh.
but I have made a categorical statement that Lordship, para 9. Para 9 of my petition, because CTC has been applied, but still the copy could not
Okay,
furnish.
criminal and the records of criminal complaint case number 26 of 2025
Yes, Lordship.
from the same court.
Yes.
Place the matter on
21st, 21st, Lordship.
21st. 21st is the opening day, 22nd. Okay. 21st or 22nd? 22nd.
22nd.
On 22nd April 2025.
Copy of license.
And please, Your Honor. Your Honor, this is a criminal petition under section 528 BNSS, Your Honor, for quashing the FIR in Niti Vihar PS case number 15 of 2021. Now, this particular application has been filed because of the settlement that has taken place between the victim and the accused persons, Your Honor. Because the victim happens to be the second mother of the petitioner number 1, who was one of the accused persons. Now,
There is a settlement deed,
yes, Your Honor. That is at page number,
Annexure 5.
annexure 5, page number 31.
So the petitioner is
The first party is
Savita
petitioner
Tayam.
number 3. Savita Tayam is the second party at page number 32, Your Honor.
Anita Tayam.
Savita Tayam and Anita Tayam are the accused persons.
1 and 2 are the
Accused
accused
persons.
persons. Okay, and the victim is 3.
Petitioner number 3.
Third learned counsel for the petitioner, Miss
T.Y. Bhutia.
T.Y. Bhutia. So this is an application under section 528 of the BNSS, jointly preferred by the petitioners slash the accused and the victim for quashing and setting aside of FIR dated 28/10/2021 in connection with Niti Vihar PS case number 15 of 2021, as well as the criminal proceedings pending before the court of the learned CJM Capital Complex UPIA under section 323/448/380/506/34 of the IPC. So, learned PP has accepted notice on behalf of the state respondents. Call for the records of the case number is,
Niti
case
Vihar
number,
PS case number 15.
PS, but you will produce, na? Because it's not charge sheeted, na?
It has already been charged sheeted.
Already charge
Yes,
sheeted.
The stage is at the stage of prosecution witness.
Then what is the case number? Which is the case number? Before the learned court. Because this is
It
only
is,
FIR number.
It is Niti Bihar PS case number 15 of 2021 and GR number 1058 of 2021, Your Honor. Your Honor will find it at page number 20,
Page
29,
29.
29. This is the order of the CC. Your Honor.
Okay. So call for the records of Niti VRPS case number 15/21 and in GR case number 1058/21 from the Court of Chief Judicial Magistrate Capital Complex at UPIA. List the matter of the receipt of the TCR.
Also, Your Honor, if Your Honor may kindly grant the interim order of staying the proceedings before the trial court.
Okay, in the interim, the proceedings before the trial court shall remain stayed till the next returnable date.
Give your Honor.
Hello. Lordship, basically, Lordship, this case was, recently it was, matter was, dismissed on this, that, condonation delay part, but, it was, observation, of this, opinion of this honorable court was that, these issues may be raised in another way. This generally, Lordship, kindly see this case is respondent number 2 is the person not charge sheeted. The brief cases. Respondent number 2 is person not charge sheeted. Kindly see the this charge sheet copy. As per the charge sheet copy in the column. Page number 39, 30. Page number 40.
24.
Page number 40.
40,
Yes,
40.
40, yes. It is a paragraph number 12. Particulars of the person not charge sheeted. That is Tabayal Nabam. This is the not, although accusation was made against her, but no charge sheet has been filed by the
Particulars
police.
of accused person, not
Yes, Tabayal Nabam. Particulars of the accused person not charge sheeted. This is the case. I am to say in this case, the investigation was biased. So during the course of investigation, what has been written here, the observation of IO was that she should be treated as approver. Page number 43, this operative person is last paragraph. Page number 43. 43. May I read the contents? Under the above fact and circumstances of the case under 376 IPC is found well established against Mr. Bisalpa Nabam. Particulars mentioned such as for establishment of sexual relationship with parties in the pretext of marriage to the victim. Therefore, I beg to send him to the honorable court to the trial and appropriate section of law. Therefore, the witnesses mentioned in column number 13, which prove the case, who may be kindly summoned by fixing a date for hearing. The court is free to discharge Tabayal Nabam, that is accused not suspected, from the liability of her bail bond and may be treated as approver against the prime accused. That is the case. So what had happened? And then before the court below, this trial court has, what has been done in the trial court during the course of trial proceeding, in the charges hearing, during the course of charges hearing, the court has said, if that is so, if the accused person not charge sheeted is to be treated as a prime this approver, in that case, whether is there any, because prime approver is the co-accomplice generally. So court has said, in that case, you have to give statement before the magistrate
Accordingly, on page number 89, annexure 5,
Mm.
trial court has passed. Page number 89, annexure 5. Operative portion is
59 and extra five.
page number 89, annexure 5.
Mm.
In this case, page number 89, annexure 5. In court has said, I am reading from page number 90, operative portion is, as this court doesn't know what Srimati Yal is going to depose before the court as a witness, therefore she shall first give her statement before the landed magistrate at UPR, disclosing on the fact of the case that she is going to give her evidence before this court during the trial of the case. Then after perusing the statement made by her, this court will decide as to whether she can be pardoned to become an approver, which witness in the case. Therefore, she shall appear before the court, before the landed magistrate UPR to give her statement. The landed magistrate shall take necessary step for recording of her statement, Srimati Tabayal Navam. The recording of the statement and forwarding of the same to this court shall be complete that on the next date of hearing. Accordingly, case was matter was fixed on such and such day. So what that happened, then the accomplice give her statement before the magistrate
Okay.
as per the direction of the court,
Mm.
trial court. But in the page number 92, annexure 6,
Mm.
page number 92, annexure 6, during the, after perusal of her statement, there was nothing on record to show that no adverse statement has been made against the accused person, prime accused person. And whole investigation process of this police investigation was completely manipulated. And she is also not ready to, although she is accomplished because of her persuasion only, that marriage was contracted as a second wife. So what had happened when she refused to give adverse statement against the accused person, then during the course of hearing, the victim has filed application under 294 CRPC for admitting electronic evidence and additional documents before the court below,
Mm.
so that may help the prosecution to prosecute against the accused person who has been discharged. But what had happened in the page number 98, annexure 7, kindly see,
Mm.
this is the discharge application.
Yes.
What court has done, 27 October 2022. What court has never recorded refused to, no any order has been passed. This admitting the additional document. First of all, that is one of the important factor. And another is, although the accused person not charge sheeted, although he is not charge sheeted, she has been discharged. When the accused is not charge sheeted, in that case, court is nothing to be discharged because she is already not in charge. Therefore, when she has been discharged,
No, in the
Yes.
charge sheet, I think the IO prayed that she should
yes,
be discharged.
yes, IO
Yes,
has not charge sheeted her.
yes.
Even then, court has discharged by this court order, 27 October 2022, annexure number 7. That
No,
cannot.
but we have also done that so many times. Like supposing in a charge sheet, initially there'll be maybe say 10, 20 accused. Finally, charge sheet may be
There-
filed against only 2, 3 persons,
There-
and the IO will pray that the remaining accused may be discharged. Then the court.
Yes,
will-
Lord, under section
ma'am,
227
ma'am.
CRPC, Lord, discharge is provision is there.
Yes.
When there's no prima facie is evidence
Not-
is Lord, against the accused, then it may be discharged by the
May
on the
I
process, Lord.
clarify?
Yes.
This is actually, this court is supposed to discharge the person when the accused is this accused is charge sheeted either by the police or by the court under 319 of CRPC. Court has implicated the accused if there is material against the accused. But in this case, neither the police properly investigated the case, nor the court
take the evidence what has been filed under 295 of CRPC for taking
What
admitting
is,
additional
what is your
evidence.
prayer? Your
Kindly-
prayer is for
kindly-
fresh investigation.
Yes, kindly see page number 102, Annexure 9. Application was filed before the trial court under section 294 of CRPC for admitting additional evidence because evidence was deficient because it was deliberate attempt on the part of the investigating authority. That is our case. And even then, neither the court take additional evidence, rather discharge the accused person, saying that there is no prima facie material against the accused person. And moreover, he is not an accused in the case. This accused in the case. This is not an accused in the case. This accused number 2, respondent number 2 is not an accused. When she is not an accused, police has not charge sheeted, then how court can discharge? Because of this discharge order, the court cannot, we are unable to prosecute this accused person because already there is a bar, there is a procedural lapses, serious procedural lapses. That is the case. At this stage, Lordship, notice may be issued and a record may be called for.
Learned counsel for the petitioner.
Lordship, actually, Lordship, this petition should have come in the revision petition, Lordship. But in revision also, limitation period already barred,
That is
90
already-
days, yes, Lordship.
Revision against is
I'm submitting on that part, it's one SLP is para number 2.
but he's
Supreme
praying
Court
for fresh
cases,
investigation of
1900, on that part, that point, law point.
Just
More-
see the prayer
More,
portion.
Lordship,
He's praying for fresh investigation
Yes, Lordship.
against the co-accused.
Yes.
Then the another prayer is to frame criminal charge against Srimati Sanyarsaj. These are-
Lordship is already exhausted the Lordship opportunity, Lordship, because here their Lordship 227 Lordship already court has discharged the co-accused Lordship, not the main accused, co-accused. When there's no prima facie material anything fine against her, then it is discharged under section 227 of CRPC. So Lordship, after that Lordship, this is way back Lordship 2022 order Lordship. Now, Lordship, at this stage, Lordship, we don't know, Lordship, at what stage the proceeding is going on, Lordship. The 2022 order.
And when court is already discharged under 227, then how can
Yes, the
fresh
fresh investigation, how
investigation
can,
be against them?
yes, Lordship. He is sleeping over his own right, Lordship. He should have come long before, Lordship, with 2022 order.
Under statutorily, that is not barred, Lordship. That is why, Lordship, I come before this honorable court.
For sitting as a-
As I have submitted, this cited Supreme Court cases in SLP 1990.
I think that
ACC.
you had approached this court earlier, isn't it?
Yes, I have enclosed the copy, Lordship.
That's why
That
it's
was in the
looking-
form of revision,
Where is that?
page number, kindly see the page number 30, Annexure 1.
Lordship has dismissed that petition, Lordship, on ground of limitation, bar of limitation.
This
Ah,
honorable court-
yes, now I
honorable
remember.
court was of the opinion that
So, yes, then there
opinion
was,
that
there was delay and then the
Yes.
limitation was not condoned. So
Yes.
your revision also gone
that is
that-
why Lordship was of the
and-
opinion
and-
that if
and under the.
on merit in another way that can be matter can be this.
No.
That was on limitation, Lordship, that issue was. Whether explanation was sufficient or not, Lordship. Whether
Yes, I remember now.
I've enclosed the copy. If that is a merit, I pleaded before this honorable court, on merit, there is a sufficient reasons.
But under 528 again, I don't know. What is
397,
your prayer is.
But is what I have cited.
Again, direction order to set aside quash impugn order decision is such in respect of co-accused. In connection with such and such fresh investigation.
Issue is lordship, when already this accused not charged sheet has been discharged, although she is not an accused, then when already she has been discharged, in that event, there is no provision under the law to reinvestigate against the accused unless that order is set aside. That is the issue here. Whether the accused is very much connected in the case. That is the issue here. That is why I have this cited this 1998 ACC
What does it say?
770 lordship and para number 2.
Yes.
This honorable court has a discretion. Discretion can be applied, lordship. That doesn't bar. That is the inherent power of this honorable court. When there is a justice is to be made to secure end of justice, the court can exercise the power, inherent power, under the given situation, lordship.
Okay. Issue notice.
Yes.
Only notice may be issued, lordship.
Yeah, only notice will issue. And then counsel for the petitioner is such and such in the present application under section 528 of the BNSS. Leonard PP L. Tagi has accepted notice on behalf of respondent number 1. The petitioner shall take steps for service on respondent number 2 by registered post with AD within 3 days. This is the matter of the 4 weeks. And call for the TCR from the court of session judge.
Session judge.
Yeah.
Scan copy, lordship.
Scan copy, yes.
Yes,
Scan copy.
there is one criminal petition is connected criminal petition is going on. That may be take together, lordship. Criminal petition number 31 of 2024. Criminal
Here,
petition,
before
yes,
this
criminal petition filed by this the prime accused. This same connected
The-
matter.
The present petition
Yes.
may be tagged with
31 of
criminal
2024.
petition 31 of
31 of 2024.
31 of 2024.
31. That may be clubbed together.
It's a list after, lordship. This matter list.
4
4
weeks,
weeks.
4 weeks.
Like,
Yes, my lord.
Oh, online. Okay. Yes. What is this for?
Yes, my lord. I'm appearing on behalf of the petitioner.
Okay.
Yes,
The fire quashing.
yes, a fire causing, my lord.
What is your ground?
My lord, we have already made a complete payment regarding the payment which I've quoted in the annexure 1, my lord.
Annexure 1.
Yes, annexure 1, page 20, page 16, page number 16.
I've received all the total amount of such and such. There's no balance to complete. The case was for what? Cheating case?
For-
For
No.
20.
Yes, 420, my lord, yes. So now, as we have already paid a full payment, so it's my prayer for quashing of the FIR number 10, FIR number 10 of 2019. It's registered on 22/9/2019, my lord.
It is charge sheeted also.
Yes, my lord, yes.
It is already charge sheeted.
Charge sheeted, that's on paragraph 4, page 18, my lord. Charge sheeted, registered number GR number 74 of 2019. And it's pending before the Honorable Judicial Magistrate First Class Kongsa. It's under page 90, 18 and 19. 18.
18 and 19. No, I think charge sheet is page 21.
21. 20,
Yes.
21. Yes, my
Final
lord.
form report. Yes, page 21.
Right.
This is an application under section 482 CRPC / section 528 of BNSS. Praying for quashing of the FIR DML / PS / C number 10/2019 dated 22/9/2019, registered at Diomali Police Station, Tirap District under sections 120B/420 and 34 of the IPC. And also the charge sheet dated, charge sheet is dated 22/9/2021.
2023.
Oh, 2023, 22/9/2023. On the ground that the petitioner has already paid the said amount of rupees 15,50,000, and the same has been received by the complainant.
Yes, my lord.
By the complainant.
Complainant. Yes, complainant. Respondent number 2.
Complainant, respondent number, complainant / respondent number 2, and hence the
Yes.
prayer for quashing of the same. So I've heard the learned counsel for the petitioner, Sri such and such, and learned PP has entered appearance for the state respondent number 2. Or respondent number 1. State respondent number 1. So issue notice to the respondents number 2 and 3. The petitioner shall take steps by registered post with AD within 3 days. List the matter after 4 weeks.
My lord.
Yes.
You may kindly
Yes.
issue notice, my lord. You may kindly issue notice on a stay of proceeding before the Honorable Judicial Magistrate First Class, my lord. Stay of proceeding. That's my prayer.
Lordship, there is no
There's no prayer, but
interim prayer, Lordship.
yes, there's no prayer. It's
Divine
okay, I'm
prayer.
sure since he has already received, he will not press.
Yes, my lord. Oblige, my lord. Deeply oblige.
Yes.
Changing my lords in FIR that has been registered against me under 498A, 494 and 506
Hmm.
by PS1. For adverting to the grounds as why I'm challenging, my lords may kindly go to the impugned,
Speak to the mic, yeah.
my lords may kindly go to the impugned FIR. That's from page number 23. My lords may kindly turn to page 24, which is the relevant.
Page
Page 24, my lords. That will be the relevant.
24.
24.
Hmm.
The impugned FIR that has been registered against. May I read it, my lords?
Yes, yes.
Yes, please. On 1/3, dates are very important, my lords.
Hmm.
On 1/3/2024 at 1400 hours, now a written FIR received from one, namely Srimati Umli Muli, 38 years, wife of such and such, resident of such and such, that she belongs to Idu Mishi community of the Arunachal Pradesh and residing at such and such with the minor son and parents, that she is filing an FIR against her husband Shri Adil Sadiq Khan, arraigned as accused number 1, and mother-in-law such and such, arraigned as accused number 2, for the following reason: that she was in live-in relation with the accused number 1 and lived at Gautam Nagar, Delhi for a few years in 2018, and then in 2019 they shifted to Srinagar
and accused number 1 was dealing with the business of bulletproof vehicles supplied to the defense in addition to the other supply orders, maintenance, repair services. On 12th June 2018, they both entered into the nikah at Dal Lake in Srinagar, Kashmir, as per the Muslim custom against the wish and in absence of their parents. As she was in deep love and completely surrendered to his wish, giving up the entire society. Accused number 1 has initially portrayed himself as a progressive individual who promised to settle in Delhi. However, post-marriage, he claimed her to reside in the rental house at Rajbagh, Srinagar. She was denied access to her original home at Vemna, Srinagar, and restricted from participating in any family celebration or the event. The culture and the custom in the new setting were markedly different from her own. Despite the stark differences, she tried to adapt and cope with the situation. Accused number 1 frequently expressed dissatisfaction about the not receiving anything in their marriage and persistently pressurized her to request money from her parents. Unable to reach her parents in the early part of 2018, she felt compelled to take the loan of rupees 3 lakh from such and such of Rohing to meet his demands. Shortly after the marriage, he started making unreasonable dowry demands. By December 2018, accused number 1 became increasingly aggressive. One day, while they were in Jammu, the accused number 1 demanded money, and when she could not get it from her parents to fulfill his demands, he dragged her from his vehicle and fled away after she fell down on the ground. She was also shocked to discover that he was addicted to heroin. He used to approach her society to demand money, and after obtaining it, he would leave her and their children alone, often not returning for weeks. She got pregnant in the month of September 2019, and her parents accepted their relationship, and therefore they came to the Rohing, where they performed the nikah again in Rohing on 14/2/2020 and also performed the customary rituals on 23/2/2020. Thereafter, in the first week of the March 2020, they returned back to the Kashmir. Her husband verbally abused her using offensive language, asserting that her parents could not meet his satisfaction, and he sold her 2 golden bangles to explicit assertions that, to explicit request to refrain from doing so, as they were a gift from the mother during their marriage. Despite pregnancy since September 2019, accused 1 neglected her medical needs. Consequently, her mother sent 30,000 on 4/6/2020 for medical expenses. When accused number 1 demanded money, and she explained that he was reserved for a medical emergency, he abused her physically and almost strangulated her, disregarding the risk to her to her health and pregnancy. Despite delivery and the challenge of COVID-19, he showed no concern for her safety. He refused a reputable hospital for the delivery unless her parents provided money, prioritizing money over the well-being. On 17/6/2020, their son was born. However, after a few months, accused number 1 began ill-treating her, almost amid the national-wide COVID lockdown of the COVID due to pandemic. Accused number 2 forced that she returned to the Rohing with the newborn despite the risk and disregard for the safety measures associated with the trap. During such crucial time, in November 2020, accused number 1 brought her and their baby to the Rohing to meet her father, who had been diagnosed with the cancer. He left promising to return soon, but he did not come back for months nor attended her calls. As her husband, the accused number 1 was not paying the rent for more than 1 year. Her landlord informed to clear the pending rent or else vacate the premises. Therefore, on 13/4/2020, she returned to Srinagar with her minor son with the help of her parents, which was not welcomed by the accused number 1. Thereafter, she was subject to the physical abuse and the mental torture on a regular basis. Accused number 1 forcibly took her ATM card and has been using it for personal pleasure, but refused to meet the basic needs of her and their son. When she informed the matter to the accused number 2, she verbally abused her and told her to go back. Left with no option on the advice of the local lawyer, she preferred a domestic violence case in the Honorable Court of Chief Judicial Magistrate in Srinagar in June 2020. basically for protection to pay the rentals of the rental accommodation and maintenance. It is crucial to note that despite the court orders, accused number 1 has failed to adhere to the directive to pay the monthly maintenance amount, thereby leaving her and their minor son in a destitute state without any financial support. After the DV case was filed, against the accused number 1, he proposed a settlement to avoid the legal case, leading us to return to the Roing on 13/6/2022. This is very important, my lords. At Roing, he demanded a car as her parents were already dealing with the expenses of her father's cancer treatment. She was forced to borrow a loan of rupees 3 lakh from the cousin such and such to meet his demand for the car. In 2022, he consistently pressurized her to seek money from her parents, despite knowing that they had already been distressed with the cancer treatment, threatening to end their marriage if the demand were not met. This has resulted in a substantial burden of loan on her shoulder. Accused number 1 was also misappropriating the earning from the daba of her father, and when she asked him to refrain from such things, he got furious and he slapped her on her face. It was intervened by her mother and stopped him from further hurting in the month of July 2022. In August 2022, he abandoned them again. On 7th March 2023, she, along with her minor son, returned to the Srinagar as she has not been attending any of her calls. Accused number 1 refused to accept her and their son and maintained them, who was fully supported by accused number 2. They bluntly told her to go back to her parents, but she refused to do so and preferred to stay. But the things deteriorated so much that in the month of May 2023, the Intizamiya Committee of the Bemna Srinagar held a meeting on the behest of the Abu Bakr Masjid meeting hall. While accused number 1 was found guilty and directed to accommodate her and their child within their family. Shockingly, instead of complying, accused number 1 sold his property and moved to a different place, abandoning them. Accused number 1 has initially asserted to have only her as a wife. However, to her shock, during the meeting, it was disclosed that he is living with another wife and has even fathered a child about 6 months younger than her son. This revelation has left her feeling deceived as he breached her trust, subjected her to harassment, and made her life thoroughly miserable. Despite her family's sincere attempts to meet the dowry demands, she has been subject to persistent physical assault, mental torture, and threat from him. Notwithstanding her initial resilience against various challenges, she eventually had to give up and was compelled to return to the parents' house in Roing 23rd of December 2023.
November, 23rd November.
23rd of November 2023. Very important date, Mike. Accordingly, on the receipt of the written FIR registered at PS Roing, FIR number such and such under section 498A, 494, 506 IPC. And the matter was endorsed for the investigation. Now, my lords, before going to the grounds, my lords, it's very important to mention that I had come before this court under section 482 CRPC. Now, my lords, the first and the foremost thing which needs to be discussed is that the FIR is at settle the investigation stage. More importantly, my lords, before I go to that ground, 498A, 494 and 506, my lords. Admittedly, I have admitted in my petition as well that both the parties, that's petitioner number 1 and the respondent number 2, my lords, they are Muslims. 494 is ruled out. It is not made out because we are Muslims. Against Muslim, you cannot slap this 494. It's a beaten law. Because we are being governed by the Muslim personal law. Unless the Uniform Civil Code will be applicable. So 494 is itself gone. No preliminary investigation conducted by the concerned IO, my lords. In fact, I would say that the law protectors here have become the law breakers. No investigation conducted. Now, my lords, I have come under 498, 482. It says, saving of the inherent power of the High Court. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code to prevent the abuse of the process of any court or otherwise to secure the ends of justice. Now we have to understand this. What do we understand by this term, to prevent the abuse of the process of the court or otherwise to secure the ends of justice? Now the first and the foremost question which comes before the court, before my lords, is that whether at the investigation stage can this court interfere under 482 and quash the FIR? This is answer to that, my lords. In order to secure the ends of justice, my lords have all the powers under 482 to interfere at any stage. It has not been limited, my lords. And more so, my lords, I say what I have gathered from 482, it can be invoked under certain situations, my lords. I have categorized them in 5 situations, my lords. First is that once there is no prima facie case. Second, once a civil dispute is disguised as a criminal. Third, once there is a settlement between the parties. Fourth, and very important, lack of jurisdiction. Now, if the FIR was filed in a police station which has no jurisdiction to investigate that matter, now can that FIR lie? I will come to this as well. Fifth is the malicious prosecution, my lords. Now, if the FIR is clearly filed with the intention of harassing someone, my lords, this court has all the powers under 482 to come up to my rescue, my lords. Now, my lords, kindly turn to page 27, my lords, Annexure P2. Now, my lords, in 2018, we entered into the marriage. Things were good up to 2022. Now, out of nowhere in 2022, my lords, she approached the local court, my lords, Chief Judicial Magistrate, Srinagar. Now, my lords, what she is writing, that is very important. My lords, may kindly turn to page 30.
30.
30.
Yes.
Yes. Para number 8. That the torture by the respondent became frequent with the passage of the time. The respondent started physically torturing the applicant number 1 more and more day in and day out. The golden ornaments of the applicant number 1 has also been taken away by the respondent number 1. The respondent number 1 is a drug addict. Hence, under the influence of the drugs, the accused number 1 loses cool and subjects the applicant number 1 to all sorts of torture. The applicant number 1 has also approached the women police station Rambagh but without any relief. Very important, my lords. In 2022, she is approaching the police in Kashmir against me under 498A. She is not getting any relief. Approaching the local magistrate here, getting a relief, coming back in 2023 to her home place, filing a complaint there, and an FIR is being registered against me. How this can be done? Isn't this the abuse of the process of the law, my lords? Very important, my lords.
So before this women PS Rambagh also FIR was filed.
No, she filed a complaint.
She filed a complaint.
She filed a complaint, but no FIR was registered because I was not at fault. And these are her pleadings filed before the court at Srinagar, my lords. And my lords, going through the all this petition, my lords, she has nowhere stated the fact that she has been tortured at Arunachal Pradesh, my lords. This is very important, my lords. I remember a very great and a famous judgment by Justice Vinod Chatterjee Kaul of Jammu and Kashmir High Court, my lords, wherein the Honorable Court has stated that once you file a pleading before one court and one pleading before the another court, and those are differentiated by a major differences, the court is well within its powers to proceed against the person who has made such accusations as false or incorrect under perjury, my lords. I will show to this court how it is blatantly, my lords, done. Then my lords may kindly turn to page 34. This is the ad interim order that was passed in her favor in the year, date of order is 15/6/2023. 15/6/2023. Her preliminary statement got recorded. Nowhere she has mentioned that she has been tortured at Arunachal Pradesh, my lords. Nowhere. Initially, she got the interim maintenance of 17,000. Then we argued the matter, that was slashed down to 8,000. And apart from that, my lords may kindly turn to page 37. My lords got it?
Page 37. Yes.
37.
Initial
Both sides are present. 10,000 has been paid to the petitioner number 1 by the respondent number 1. On consensus of both the sides, the interim direction pertaining to the residence order is hereby modified to the extent of 4,000. We shall be paid in addition to the interim that was passed by the court, my lords. And my lords, what she is challenged, what she has stated before this in the impugned FIR, my lord, she has stated that because of the non-paying of the monthly maintenance amount, she had to return back to the Roing. Now, my lords, if that is the situation, why didn't she approach the local court here? Why she has already filed a domestic violence petition? Now, my lords, kindly turn to Annexure 5, page 39.
Yes.
This is her evidence affidavit, which she has filed before the Court of Second Additional Munsif, Srinagar, while her case is sub judice, my lords. Nowhere, my lords, nowhere she has asserted this fact. In fact, this has been filed on 9/10/2023. Nowhere she has asserted the fact that she has been tortured at Arunachal Pradesh, or even the petitioner number 1 before my lords have ever come to the Arunachal Pradesh, my lords. Nowhere she has mentioned. A blatant lie, this FIR. Annexure 5, my lord, she was
This evidence is dated.
evidence affidavit taken in the petition.
Court of First Class Magistrate, this one.
This is before the Honorable Court of Second Additional Munsif, Srinagar, at the top, my lords. My lords, let me see. Page 39, my lords, you see?
Yes, page
Yes.
39.
Before the Honorable Court of Second Additional Munsif, Srinagar.
Date.
Date, my lords, make
2/6/2022.
Now those approved.
Because the date of the
No. My lords, may
evidence
kindly
is not given here.
the date of filing is on the left side. Here, my lords, may kindly see. On the left side. On the left side of the front page only. Page 39.
This is page 39, Annexure 5.
Page number. Lords, may kindly see this evidence affidavit. I'm dealing with the
I
evidence
think
affidavit.
page 42. 9/10/2023.
Maybe, yes. 9, 10,
The
20,
pages are not.
maybe
matching.
we have miscorrected ourselves, my lords. 9/10/2023, my lords.
Yes, anyway, continue.
Yes, anyway. 9/10/2023, she is stating before the court that she has been tortured in Srinagar only, not in Arunachal Pradesh. However, in in March 2024, she is filing a complaint before the police station whereby she is stating that I have been tortured at Roing as well as in Srinagar. Why such fact has not been narrated before the court? Once you are not narrating any fact before the court, and once that is not admitted, you need to, burden is upon you to prove it. Non-mentioning means it has not been done. Now, my lords, I take 4 grounds to challenge this impugned FIR. Now, my lords, 177 CRPC. 1, 2, 3, 4, 5, 6. Now, my lords, first and the foremost, importantly, she has stated that she has been beaten up in the domestic violence petition. What she has narrated, she has been beaten up in Srinagar. Now, my lords, going through their objections, it has been admitted by the other side as well that yes, she has been beaten in Srinagar. Now, to manipulate the things, they have stated that she has been beaten in Srinagar as well as in Arunachal Pradesh. However, the pleadings before the court, which carries a great evidentiary value against them, they have narrated that she has been beaten up in Srinagar only. Now, my lords, section 177 of the CRPC, it says that an FIR is to be registered while the offense is taking place. 177. Now, my lords, coming back to the 482, whereby I have stated that there are 5 grounds whereby this honorable court do have the power to quash the FIR, is that once there is a lack of jurisdiction. The Roing police station does not have any jurisdiction. Even this is not a zero FIR, whereby the FIR can be registered and sent to the police station, whereby the offense has been committed. This is not that FIR, my lords. Now, my lords, once the essential ingredients are not made out, the FIR cannot run, my lords. It's a beaten law. My lords must be aware about that. And my lords, it is the chapter 8 which deals with the jurisdiction point. Chapter 8 of the code, the jurisdiction of the criminal courts in inquiries in the trial. Now, my lords, a very important point is, my lords, may kindly again turn to page 23 for a minute. My lords, got it?
Page?
Page 23, my lords. 23.
Yeah.
My lords, got
The
it?
FIR.
The FIR. My lords, may kindly see the info under point number 3, the occurrence of the offense, then it is the day, time, then the information received at PS 1/3/2024.
Where do I find that?
My lord,
Serial number?
at point number 3,
Point number 3, occurrence of offense.
occurrence of offenses, then point number B, information received at PS.
Upper B.
Information received at PS 1/3/2024.
24.
My lords, got it?
Yes.
My lords, got it?
324.
Then my lords, referring back to page number 23 for a minute, please, my lords. Page 25, sorry, page 25. Last but second line, my lords. Notwithstanding her initial resilience against various challenges, she eventually had to give up and were compelled to return to the parents' house in Roing on 23rd of November 2023. So where she has been for 5 months? Why there so much of delay in filing the complaint against me, my lords? And in fact, that has not been reasoned as why there has been delay in lodgement of the FIR against me, my lords. Now, my lords, I am referring to these judgments. I'll be only quoting the ratio of these judgments. The ratio, in fact, I have highlighted at the top of every judgment, my lords. First is the Dhananjoy Biswa, sorry. This was passed by this honorable court only, whereby it has been stated, the FIR has been registered in this, my lords, whereby the honorable court at the end of the trial came to the conclusion that the FIR has been registered just to harass the petitioner. And my lords, on that point, only the impugned FIR was set aside, my lords. That is at page number 13, my lords. In fact, the judgment is passed by this honorable court only. at the end, my lords.
Last page. Page 13.
Page 13 is the last page,
Yes.
para number 31. Thus, this court is of unhesitant view that the institution of the criminal prosecution against the accused in the GR case number such and such through the FIR by the informant is not for intention which can be termed as bona fide. Rather, it goes to show that the launching of the criminal prosecution by the informant through the FIR is to use it as an instrument of harassment and to vigilance on the accused person. And on this point only, my lords, this honorable court has come to the conclusion of the petitioner in this judgment, my lords, and quashed the FIR. Then, my lords, is there another judgment? Supreme Court, Mahmood Ali versus State of UP. My lords, got it? Once there is delay in lodgement of FIR and same is not explained in the FIR, then in that situation an FIR needs to be quashed. This has been retaliated by the Supreme Court in 2023, my lords. It's a very long judgment. It will take time, my lords. So I have highlighted each and every para which is relevant in my favor. The ratio is once there is delay in FIR and same is not explained in the FIR, then it needs to be quashed. Then, my lords, another judgment is the State of AP versus M. Madhu Sudan Roy. This again, delay in FIR, delay in FIR, but not explained. Then, my lords, judgment of 2024 passed by the Delhi High Court on the same set of facts which I am having, whereby the essential ingredients were not made out and the relatives being unnecessarily dragged in the FIR, and there is a delay in FIR. The Honorable Delhi High Court came to the conclusion of the petitioner, my lords, and ultimately quashed the FIR, my lords. Last but not least is the once no preliminary investigation is conducted, my lords. This passed by the Jammu and Kashmir High Court, my lords. Saeed Rafiqul Andrabi versus Irshad Ahmed Kamli. Again, once in 498A, once no preliminary investigation is conducted by the concerned police station, in that situation, the FIR needs to be quashed, my lords. But before understanding it, my lords, actually, who did the judgment? I'll be referring to just one judgment. That's it, my lords. Now, my lords, one judgment which changed the whole scenario of the criminal side is the Bhajanlal versus State of Haryana. So must be aware about that. The Honorable Court, the Supreme Court framed 7 guidelines. If I fit in one of the guidelines, the court is well within its powers, no matter whether it is the investigation stage or it's whatever stage, my lord. Court is well within its power to quash the FIR. That is guideline number 7. I will read it, my lord. While a criminal prosecution is manifestly attended with a mala fide or while the proceeding is maliciously instituted with an ulterior motive for vectoring vagrants on the accused person and with a view to spite him due to private or personal grudge, my lords. This is where I fit, my lords. She is approaching police station in Srinagar, not getting any relief, approaching the local magistrate, my lords, getting the relief, but not satisfied with that, wants me to be harassed like anything, frames me and my mother as an accused in the Roing police station so that I can come up here again and again, feel a sort of harassment. My lords, I say that this court is well within its power under 482 to quash this FIR, because ultimately I am covering up with the whole scenario or whatever the grounds I have taken, my lords. If there will be anything, my lords, it won't be possible for me to again come up physically before the honorable court, because I have come up from Jammu and Kashmir, my lords.
This
Oh.
will complete it today.
Yes.
Lordship, and for the state and is for response number 2, Lordship. Lordship, I have also submit, I have to submit, Lordship, because case diary, scan copy of the case diary till the investigation state, Lordship, is with me, Lordship. Because investigation was state, Lordship, on the dated 12/3/2024. The Honorable Court has stated the procedure, the investigating, Lordship, investigation. Till the date of 12/3/24, I have the case diary, Lordship. Lordship, because of the stay, Lordship, investigation could not be proceed further, Lordship. And so, Lordship, moreover, the Lordship, the judicial issue, Lordship, I have a judgment of Rupali Devi versus State of Uttar Pradesh, wherein the Lordship, where if the Lordship, in the paragraph 9, Lordship, it is here, Lordship, it says that the continuing offense is one which is susceptible of the continuous and is distinguishable from the one which is committed once and for all. Each one of those offenses which arises out of failure to obey or comply with a rule or its requirement and which involve a penalty. The liability for which continues until the rule or its requirement is obeyed or complied with. On every occasion, that such disobedience or the non-compliance occurs and recurs, there is an offense committed. The distinction between the two kinds of offenses is between an act of omission, which constitute an offense once and for all. Yes, Lordship, this for Rupali Davis is Lordship, Cabinet Appeal number 71 of 2012, Lordship.
Year 2012?
Yes, Lordship. Lordship, here, Lordship. Lordship, the Lordship, my learned colleague has, Lordship, has shown the Lordship, the order, Lordship, 15/6/2023. But this is the order, Lordship. But the court, before that, Lordship, it is presented before that court on 2/6/2022. And Lordship, and Lordship, after Lordship, this Lordship, before this presentation of this order, Lordship, she came back to the drawing with her family. Lordship, in the FIR of the Lordship, this victim, Lordship, which he has, Lordship, lodged before the drawing PS, Lordship, on 1/3/24, and it is registered on 6/3/24. Lordship, why it is late? Because, Lordship, there is a trauma she was going through, Lordship, and then in the FIR, Lordship, in the FIR, Lordship, it stated that, Lordship, when she, Lordship, she came back, Lordship, on the June, Lordship. After the DB case was filed against the accused number 1, I proposed to settle to avoid a legal case, leading us to return to drawing on 13/6/22, Lordship. And at drawing, he demanded a car. As my parents were already dealing with the expenses of my father's cancer treatment, I was forced to borrow a loan of rupees 3 lakhs from my cousin, Miss this, to meet his demand for a car. Again, in 2022, he consistently pressurized me to seek money from my parents, despite knowing that they were already distressed with the cancer treatment, threatening to end their marriage if their demands were not met. This has resulted in a substantial burden of loans on my shoulders. Again, Lordship, accused number 1 has also misappropriating the earning from the daba of my father, and when I asked him to refrain from such thing, he got furious and slapped me hard on her face. It was intervened by my mother and stopped him from further hurting me in month of July 2022. That is, Lordship, this Lordship incident occurred in the Lordship drawing, Lordship, in Arunachal Pradesh, July 2022. Then in August 2022, he abandoned us again, Lordship. And Lordship, on 7 March 23, I, along with my son, returned to Srinagar, Lordship. That means, Lordship, from June, Lordship, before passing that order, Lordship, this DB Act order, she came back to the drawing, and till 7 March 2020, she was here, Lordship. And again, on 7/3/2023, she, along with her son, returned to Srinagar, and he was not attending any of her calls. Lordship, here, Lordship, this conduct of the accused, Lordship, he, Lordship, when the Lordship, before the passing that order, Lordship, she came back with this accused lordship, the
Which
rowing.
order, the
Yes,
DP
lordship.
order?
Lordship, yes, that's lordship, my learned colleague has lordship shown lordship on the page 34 of the petition. Court of Second Additional Lordship, Joseph Mr. First Class at Srinagar lordship, 15/6/23 lordship. Here lordship, the interim protection was sought by the petitioner lordship. That order was lordship passed on 15/6/23, but lordship, it is presented before that court on 2/6/22, 2022. That is much before she came back to the rowing lordship. Before she came back to rowing, she was there lordship. And before that order was passed only to 23. How then lordship, my colleague has submitted that she could not whisper any lordship this violence occurred in Arunachal because that time she was not in Arunachal.
15/6/2023 order.
Yes, lordship. The order
You
was
were
passed on
saying that the case was presented when?
2/6/2022. Lordship, it is here, lordship.
In the FIR, na?
Yes, lordship. Not FIR, lordship. In the order itself is reflected, lordship, in the page 34 of the petition.
Okay.
And the application seeking it.
Presented on 2/6/22.
Yes, lordship.
That order was passed on 15/6/23.
Yes, lordship. And lordship, maybe lordship, she was lordship got some relief so that she wanted to lordship start fresh lordship with his this husband lordship. So they came together lordship to rowing. But here also lordship, his violence is still continue lordship. And that the evidence lordship is there lordship. The witnesses that victim's murder in front of her lordship, he slapped the victim lordship. That is reflected in her FIR. So lordship, how come that jurisdiction issue lordship? Because that this course of action lordship again arise in the rowing lordship on the in the year of 2022 before passing this order. And lordship, if lordship, their lordship, because of their religion is lordship 494 not attracted, but 498A and 506 is attracted lordship. So that's my humble submission is that lordship, let the investigation be continued. It stay may be vacated lordship. Because of that stay, the investigation cannot be proceed further, and the accused person could not appear before the IO for the further investigation. Their statement could not be taken place lordship because of this stay order. Moreover, lordship, I have submitted the
So
Rupali
you're
Devi
saying,
lordship.
what you're saying is at the time of filing the FIR,
Yes, lordship.
the harassment was at rowing.
Yes,
And both
lordship.
of them were there.
Yes, lordship. FIR was lodged lordship after the lordship incident was done lordship in the rowing. Some delay is there lordship, but delay lordship is not lordship that much of lordship means lordship, because lordship there is just mental trauma lordship, and moreover the delay not that much of delay, only a few months. And lordship, moreover lordship, this 2023 this order was passed in
But that has to
2023.
be explained. No, if the delay is there, that has to be explained why it was delayed.
That's why lordship, we have to this investigation should be carried out.
No, in the FIR itself. Because see, FIR is
You are telling somebody.
page, that is FIR page.
Page 23 starts from page 23.
23. You came back to rowing on 23rd November.
Oh, my lord,
2023.
my point was different, my lord.
No, lordship, he
My lord
came to
misunderstood me.
rowing lordship. On 13/6/2022.
My lord misunderstood me. My point is different, my lord.
Hmm.
I say She came back on 23rd November 2023, but the alleged harassment to her is of the year June 2022. So they have to give the explanation from June 2022
Lordship,
up to March 2024. There is a delay of 2 years. It's not few months, my lords.
Not
It's
24,
only few
Lordship.
months that
They-
she landed here. She landed here in November 2023. But the allegations of the June 2022, my
Lordship,
I
they,
think my lords,
Lordship, they went back to Srinagar 7 March 2023. Again, on the 23rd November 2023, she returned back to the Rohing, Lordship, because she was compelled to return to her parents' house in Rohing to 23rd November 2023. 23rd November 2023, she came back to Rohing, and this FIR she lodged on first of
March
24.
first of
March.
March 2024. Yes, Lordship. November, December, January, February, March. Only 3 months, Lordship. There's not so much of delay, Lordship.
Okay, then what else? So you're saying that your submission is that investigation should continue?
Yes, Lordship.
And
Investigation
it
should be
be vacated.
continued, Lordship. And the state also passed earlier should be vacated.
I'm sorry, Your Honor, my lord, that the leading counsel of this private respondent number 2 is out of station due to sudden demise of his maternal uncle. This morning only he left, so his part of argument may be keep reserved. Till that-
How can that be? Tomorrow?
Tomorrow, yes, tomorrow.
We are not here, man. We are leaving by night.
VC? Sure, VC. Oh, but you'll be on the journey.
Possible tomorrow. It's not
possible
possible
tomorrow.
because we'll be reaching to Kashmir on 14th now. We have some work. to
And
do.
this bench, I don't know when it'll meet again.
Tomorrow, this bench is last day of this.
Yes.
Not possible for us because we are leaving right now.
I'll have to release it then.
AC
You should have mentioned from the beginning, no? That
they
the
have-
council is not there.
They have come from such a long way, so I thought that I should let them.
No, but now it's coming up to the same thing.
Then why not
If
let them
possible,
let them
BC
file
also-
in writing by tomorrow so that
Lordship,
my
it's already they have filed the affidavit, Lordship. They have filed.
already filed.
If possible, it can be conducted in BC, Lordship, through BC.
No.
No, not other day.
Another
Other-
day,
Yes, Lordship.
not
It can be,
tomorrow.
it can be
no.
possible.
Because
fact,
Lordship
it
has
can be
already
put
heard
the
so
line.
much, Lordship, so it may continue before the Lordship. It would be more
Uh,
Why
appropriate.
not we fix it any day when my lords will be holding the PNP court?
That we can't say, no, that I can't say. Because the roster is made monthly and we don't know where we'll be going.
It can be
Uh,
kept as part heart and through BC Lordship, it can be conducted after opening of the court.
But we see also. no. I think it's best if I just release it. More.
If possible, we are leaving.
They're
We
leaving
have
today.
to take the flight from Guwahati tomorrow.
So they have to go down tonight.
Once we'll be traveling by night so that we can reach in the morning to Guwahati.
Okay, keep it part third. We'll see what we can do.
There be any fixed date or not?
We cannot give a fixed date, no, that is the problem.
So-
And the senior also, leading
Why-
council also, he doesn't know when he'll be back.
How we can
Isn't
be
it?
informed?
Mm.
We can be informed by those.
The registry here will inform you, yes. from wherever I am, I will inform the
Yes, yes,
registry
sure.
there, and then we can fix a VC. Part.
Much obliged, Lordship.
Also, if there, I have to say,
Say list after 3 weeks. then.
my lords, I have to say something in rebuttal. I'll be submitting that after their arguments are completed. After their arguments are,
Uh-huh.
after respondent number twos are, then I will do that.
3 weeks.
My lords, may kindly dispense with our physical presence, my lords.
So you can appear through VC, no problem.
No, my lords, this court has directed twice to appear physically before the court.
Oh, acha.
That is why we are, otherwise we won't be here.
Okay.
Yes.
The appearance of the learned counsels for the petitioner is dispensed with. Physical appearance.
Physical.
Dispensed
After 3 weeks. That will be.
And Lordship, this matter is again listed after 3 weeks or what?
Yes, this one, 3 weeks,
3 weeks.
and within that time,
Yes, Lordship.
we'll see where we can fix, how we can fix it. No?
Yes, Lordship. Much obliged.
By VC or otherwise, if I'm here, well and good. If I'm not here, then
Through VC, Lordship.
Right. The leftover matters.
I leave back. Thank you. Full attire. Sorry.
After 2 weeks,
Item 9, the next one, Malad. It's an injunction matter, Malad. I understand. In fact, since yesterday, I've been waiting for this matter. I thought, Malad, I thought that I will make a prayer for unlisted yesterday. Your Lordship rise from the division bench so late. I did not want it to bother it. And therefore, it has come today.
what can I say
Uh,
now? What can I say?
If your Lordship can take up tomorrow, my lord, I'll just take a, but I won't take much time. 10 minutes I can look. This order which was rejected, my lord, injunction, not even a hearing was done.
Lordship,
But this court has to pass order, no, whatever order it may be, and then I'll have to
Yes.
wait, and then my train is at tomorrow evening. I'm going back.
I understand.
Yeah.
But all throughout the
Next week.
all throughout 2023, we had an injunction. In fact, the court modified the injunction in our favor. But subsequently, when we asked for an amendment in the plea, court said as the amendment has been allowed, therefore the instruction.
No, what I'm trying to say. Your submission may be short, it may be brief, but the court has to pass an order. The court has to wait to sign the order. By that time, the train will be
Well,
gone.
the only difficulty is, if the injunction may get frustrated.
Lordship.
It may
So
not survive.
only 1 week.
Lordship, in item 9, we have received the service copy by this afternoon only. And the attending counsel for the tourism department, that is the respondent number 1, 2, and 4. Not present today. So
It's filed yesterday.
it's better,
Got the copy
this matter may be,
The one. This
Lordship,
letter,
no, item 9, in item 9.
they have received only.
We have
today.
received the copy of this afternoon only.
This
So
afternoon,
It
yes.
was.
then
filed
we have to
yesterday,
take, since this is
without
a,
serving a copy, it may not.
Lordship, since this is a departmental case, so we need to take proper
In
instruction
any
from,
case, not possible today or tomorrow.
therefore, Lordship.
This
It
is
will be
matter
better if
After the puja vacation, after the puja vacation.
after
21st,
nine.
place it on 21st.
21st, no, about 22nd.
Lordship, it's regarding item number 22. 22, just service is awaited. So allow us to reserve again that copy. The service respondent, private respondent number 2. Yes,
Item,
item number 22. Yes,
petitioner may be allowed to take 3 steps on for service on respondent number 2.
yes, Lordship.
This is the matter after 3
Four-
weeks.
Yeah, 4 weeks,
4
4
weeks.
weeks.
After 4 weeks.
Highly obliged.
If you have 21, can it be 22nd?
22nd. then.
Lordship, item number 10, it speaks for a hearing on CD. TCR was called, and the case was not charged sheeted at the time when it was filed. Now, when the CD was called, it has come to know that it is charged sheeted. So, on 21 of April, he is called for appearance. So, by enlarging from the custody, eligible person need to look for counsel to defend himself in the court, Your Honor. So it's a very urgent matter. So if it could be managed tomorrow.
Okay, let's see, we'll try tomorrow,
No, most of it.
but if time
May I-
doesn't allow, yes.
May this item number 23. We are appearing is respondent is also appearing. We have made a paper public. That may be party appeared and let the fix for hearing over the.
Your Lordship, I'm for the respondent. I filed my wakalat number today on my Lordship,
Oh,
Supplying the copy.
okay, okay.
and I have not received the petition.
Item 23, no? Learned counsel for the respondent number
Two.
2 has entered appearance only today. The counsel for the petitioner shall serve copy on the counsel by tomorrow,
Yes.
by tomorrow. And list the matter after 3 weeks.
And
Highly obliged.
after 2 weeks.
After 2 weeks, after 2 weeks.
And one more submission there. There's the item number 11. This is a bail matter. If
Hmm.
this matter is fixed on no matter. Bail matter. Already 47 days in the. If 55 days in the custody.
Tomorrow also we'll be having division bench, na?
And
Then after that.
can it be?
No, no, let
Can
it be,
matter
let it be
11?
after bill,
11?
after bill. After bill. Tomorrow is 11th. After bill. List all matters after bill.
Lordship, there is a bail matter, Lordship, anticipated bail matter, 12, 13 and 14. Can it be taken up tomorrow, Lordship? CD is here, Lordship. 12, 13 and 14.
13 and 14. CD has reached.
Yes, CD is here. I'm told that CD is here.
Okay, we'll see. If there's
My lord,
time permits
Item number 20.
tomorrow. No. 20,
Yes. We will take a press step.
yes.
Press step. We will
First
take
steps, first
yes, my
steps.
lord.
For respondent. Private respondent.
Petitioner
No, no. You take first steps on.
on respondent, yes.
Learned counsel for petitioner prays for permission to take first steps for notice on the respondents. Prayers allowed. The petitioner shall take first steps on the respondents and matter may be listed after 3 weeks, 4 weeks.
May I proceed, Lordship? Item number 17, my lord. In this matter, the leading counsel Subbu Koeng instructed me that this matter may be fixed for the final argument.
Item 17.
Item 17,
You're mentioning on behalf of petitioner.
petitioner Subbu Koeng, leading counsel,
Okay. When do you want?
for the final argument, Your Honor.
Okay.
Yes.
No, but how can we say final argument? It's in order column.
That's true. In the last part, the senior counsel instructed me that the orders part of the submission will be completed, only the final argument remaining. So maybe it's listed there in the order list. So it better if possible, my lord, may
17.
for final argument.
Prayer of learned counsel for the petitioner who makes a mention on behalf of the leading counsel is Koyang. List the matter after 3 weeks in the order column. However, it is mentioned that only the final argument needs to be made. Is that right?
Much of
Accordingly, an effort may be made to dispose of the matter at the next.
much obliged.
Item number 18 may be listed after 3 weeks.
Item 18,
18.
yes.
On
When-
behalf of N. Dangan.
When do you want?
18, after 3 weeks.
After 3 weeks, 18, no, that's why I'm saying all matters we are adjourning.
Okay.
After 3 weeks.
Much obliged.
Madam, iba the nine to kita pun sa din. Okay, nine. Fix it, fix it. Nine to item nine. Oh, it's for 30 point eight. Yeah.